Miss Hussain, we'll finish up the top of the list matter, then pass the orders.
Yes.
First, the top of the list matters we'll finish and then pass the delivered orders. Senior file, but the other two files I'll have to just go once. Yes.
May I please, Your Worship?
And then
Three also, we'll pass the orders after the top of the list items.
My lord, with regard to item number 51, my lord, respondent number 5, my lord, file affidavit, my lord. Always need some time. So, time may be given to reply.
When did the affidavit, when was the affidavit filed?
By the respondent number 5, my lord.
When? Long
One-
back.
Long back.
Oh.
And for the first time is seeking just a little accommodation because incumbent is the election.
Mr. A.K. Hussain, learned counsel for the petitioner, submits that an affidavit has been filed by the respondent number 5, and he prays that he be permitted to bring on record a rejoinder thereto on or before 24/2026, registered to list this matter along with the said rejoinder on 24/4/2026. No further adjournment shall be to the petitioner for filing of a rejoinder in the matter.
Hello.
Yes, Mr. Gusant.
My lord, I may be allowed to withdraw item number 42, my lord. This may be dismissed.
No steps taken, nothing.
My lord, no instruction.
No
I
instruction.
have tried by letter this.
Mr. S.S. Goswami, learned counsel for the petitioner, submits that he be permitted to withdraw the writ petition. Also, prayer is not objected to by the learned counsel for the respondents. Accordingly, the present writ petitions, on the prayer of the learned counsel for the petitioner, the writ petition stands dismissed as dismissed on withdrawal. Actually, there is a projection problem here. They had sent a requisition
My lord,
for SC,
my lord,
but that was only a part of a larger recruitment process.
my lord,
So in the larger recruitment process, they have given ST, they say it may be for Meghalaya,
my lord,
it may be for Assam.
my lord,
So you were not prejudiced as such in that selection
Fine.
process.
my lord. My lord, for abandoned question, liberty may be granted.
There is nothing here,
Fine.
nothing here.
My lord.
I have gone through,
But
nothing is.
I have taken the consent of the other side also.
May I please, Your Lordship? Lordship, with the consent of other side, my lord, I beg to mention item number 5, my lord. May I come after Bihu, my lord, because my senior, Mr. Waidolo, is in Itanagar branch, my lord.
You argue no adjournment in top of the list, by the way. You argue.
Item
lord,
number 5, I'm. abstaining.
Five is,
But- My lord, extremely sorry, my lord, item number 4, my lord.
sorry, no
Senior
adjournment.
instructed me.
No adjournment.
Please, Your Lordship. Lordship, I beg to mention item number 13, Lordship. Lordship, I may be allowed to withdraw this matter as the matter has become infructuous, Lordship.
You have been permitted to undergo the course.
Yes, Lordship, yes.
Mr.
A. Sarania, appearing on behalf of M. Sarania.
Mr. A. Sarania, learned counsel, appearing on behalf of Mr. M. Sarania, learned counsel for the petitioner, submits that during the pendency of the present proceedings, the petitioners have got the relief as prayed for in the writ petition. Accordingly, he prays that the matter be closed as having become infructuous. Prayer is not objected to by the learned counsel for the respondent. Accordingly, the writ petition stands closed on having become infructuous.
My Lordship, I beg to mention item number 40 and 41, my lord. I have to file affidavit in opposition in 41, my lord. Kindly 2 weeks time may be granted, my
You
lord.
are appearing for whom?
I am in 41, my lord. Joint of.
Joint Takumar.
Yes, my lord.
What happened to your departmental proceedings?
It is still pending, my lord.
You have retired? No.
No, my lord. My lord, immediately after Bihu vacation, my lord.
Will be on 23rd emergency laws. Chief already directed to consider market, they have rejected in second time. Now, this is my 4th time also.
Mr. A. Kolita, learned counsel for the petitioner in WPC number 6724/2025, prays that he be granted. You are filing affidavit where?
In item number 40, my lord.
Okay, learned counsel appearing for the respondent number. Respondent number
Respondent number 6, my lord.
6. Submits that he be granted a week's time to, 2 weeks time to bring on record affidavit on behalf of the respondent represented by him. R5 is, I think, the R5 has filed an affidavit here.
Selection committee has. filed.
Selection committee has filed. Prayer accepted. The affidavit on behalf of the respondent number 6 be brought on record on or before 2026. Registry to list this matter again, along with WPC number 6724-2025 for admissions on 23/4/2026.
Obliged, my lord.
Deeply aware.
Yes, Mr. Das.
My lord, I beg, with the consent of the petitioner, my lord, I beg to mention item 23 to 26, my lord. In here, we need to file affidavit, my lord.
I'm for a petition.
Our instruction of receipt, my lord.
That parity between
Madam, madam.
assistant librarian and head assistant. Both are grade 3 posts. Both are grade 3 posts.
My lord.
Now they have been given 8,000 or 8,700.
8,007 in that.
Earlier, the library assistants having more. 3,000, 3,100. Then it because of the district level posts being, DC courts posts being, finance has filed an affidavit.
Finance file affidavit.
What more is required? The
No,
finance-
actually, some instruction has been received by us, but that is not sufficient to file.
Mr. S. Das, Learned Standing Council, item number 23 to 26.
26.
S. Das, Learned Standing Council, Higher Education Department submits that he has received instructions and would file an affidavit on or
No.
before.
My lord, I have received instruction, but that is not.
No,
enough
but
for-
when will you submits that he would file an affidavit in the matter on behalf of the respondents represented by him?
BU vacation, madam.
No, give me a date.
Uh,
By 30/4/2026,
Yes, madam.
registry to list this matter. First, petitioner is at liberty to bring on record his rejoinder thereto on or before 8/5/2026. Registry to list this matter again on 13/5/2026.
my lord. My lord, similar prayer, my lord, with the consent of the petitioner with regard to item 20, my lord. 20 here, my lord, the affidavit has been sent
Oh,
for
you
vetting.
wait,
I
you
will
wait.
file.
We will take up the item number 20 is connected to 16 and 17.
No, that is not actually connected, my lord.
Connected, but
Yes.
here he has gone for a recruitment for
Recruitment,
the post
yes,
of library
yes.
assistant. You
And
say
there-
that the PWD post was read, he is only 10%
Yes, my lord,
disability.
my lord.
We'll consider that.
Here, my lord, we will be filing affidavit. Actually, that has been sent for vetting. We will be filing.
Okay, 20. On the prayer of Mr. S. Das, Learned Council for the petitioner, for the Learned Standing Council, Higher Education Department, registry to list this matter again on.
Anyone?
My lord, I am for the college authority in both the cases, my lord. Due to the interim order, my lord, college authority is suffering. That may be fixed in item 17 and 20,
17 we are taking up.
my lord.
7 days?
20 is different
Yes,
issue.
yes,
My
my
lord.
lord.
On when? When can you file the affidavit?
After 2 weeks, my
No,
lord.
give me a date.
But, or immediately after BU vacation or before.
On 27/4/2026, the affidavit on behalf of the state respondents be brought on record on or before 23/4/2026.
Yes, yes. Much obliged.
Wait, please, Your Lordship. Lordship, I beg to mention item number 7, Your Lordship.
7.
Yes, Your Lordship. Lordship, Learned Arguing Council is on leave, Your Lordship. Yes,
A prayer is made on behalf of Mr. S. Rahman.
no, Your Lordship. MD A. Rahman on behalf of AW Aman, Your Lordship.
A prayer is made on behalf of Mr. A.W. Aman, Learned Council for the petitioner for an adjournment in the matter on account, on the ground that he is not present in court on account of certain personal inconvenience. Prayer accepted, registry to list this matter again on 21/4/2026.
Obliged.
Please, Your Lordship. Lordship, actually, I beg to mention item number 11. In this case, though our name has been shown, but we have already returned a brief.
Okay, forget it, don't come. 2019
Item 11,
matter, we are not adjourning it. You don't come.
Lordship.
You come and make that reiterate that prayer. If there is no other counsel, we will take the necessary step. Yes,
What's my senior is port number 20.
your senior has difficulty. What is this matter? Huh? You have produced the forged certificate, right?
I don't know.
By at 2:15.
My lord,
If he's not there, ask him.
Well,
We
I
are
mentioned-
not concerned with the respondent.
obliged.
You have filed your affidavit, you have done your work. We want the petitioner. 2 p.m. 2:15. Sorry, I'll sit at 2:15. 2:15. Bottom 2:15 or itu matiba.
Net, please, your lordship. Lordship, the petitioner has already got the relief mail.
Ms. J.M. Kaur, learned counsel for the petitioner, submits that during the pendency of the present petition, the petitioner has been afforded an opportunity, appointment on compassionate grounds, and accordingly, he submits that the present
Serial
petition
number
be closed as having become infructuous.
Serial number 10.
Has been appointed on compassionate grounds, wide order dated 2/6/2020. So accordingly, close that. So in view of the above submission of the learned counsel for the petitioner, the present petition stands closed on having become infructuous. The order dated 2/6/2020 as furnished by Ms. J.M. Kaur is kept on record and marked as X for the purpose of identification.
Give your.
Lordship, the conducting council has not been able to conduct with the petitioner, Lordship.
To argue, what is there? Who is the conducting counsel?
Table, Lordship.
Huh?
Table, Lordship.
Argue. Just show me that the contract was subsisting when you filed this case. Forget your termination. You filed this case in 2018. You were terminated in 2016. Your contract came to an end in 2017. So, madam, you prepare. We'll take it up after some time. Yes, your form.
Respondent, item,
Private respondent.
private respondent. Sono,
There is no private respondent here. Item number
human.
8. Oh, you're there. 6.
6.
When were you implemented? You're working there now.
Yes.
ISIS anyway. When were you implemented, Mr. Bin?
Respondent number 6. It is WBC 8201.
Hmm?
8201. WBC 820.
It's 6.
666. Sorry.
I'm sorry.
Sorry. 6. Yes.
Lordship, there has been no communication with the
Forget it.
petitioner.
What is there, we will do.
Since
If
before 2010.
you withdraw, otherwise, we can't help it. You all, where is your senior?
He's out of station, Lordship.
If he is out of station, why a mention memo was not circulated? Adjournment slip was not circulated yesterday. How long have you been in practice? How long have you been an advocate?
Since 2020.
Huh?
23, Lordship.
23. Look, you're pretty singing. Prepare. Give me 1 point. I'll allow the petition. 1 point. When you are ready, madam, just come and tell her. Yes.
Challenge has been put to the appointment of the private respondent
Hmm.
as Anganwadi
Hmm.
worker, my lord, and I am the Anganwadi helper in that particular center, my lord. The allegation is that she is not a resident of that particular area. So no inquiry has been held till now, and
Now that you want the post vacated so that you can be considered for promotion.
I fulfill the experience also.
Yes, what do you say about the fact that you are not a resident of the area?
At the time of my appointment, I have satisfied the authority, my lord.
What is the material? You have not even filed an affidavit here. The
No.
government has not in, so
No.
Nasim, but we will
try to
allow
put-
it.
It is 18K matter, my lord. My instruction is that last time when matter reached, they said we have compromised. My client has informed me that we have compromised and
The petitioner has no,
Maybe you have compromised, but that compromise has not come to Mr. Bhardwaj.
they are not coming, my
No.
lord. All matter, this is the problem. So may I pray, my lord, one thing, my lord, that the district authority is there. Let them examine.
Yes, what is your material to show that she is not the resident?
Examine.
Other than your representation.
I filed a complaint, my lord. I filed a complaint and there were multiple complaints. And there is one particular letter to address to the CDPO from the subdivisional officer at page 27.
Laha.
An inquiry was requested to be conducted.
The petitioner, by way, heard Mr. Bhardwaj, learned counsel for the petitioner. You are there in the case. MP Bhardwaj, learned counsel for the petitioner. Also heard Ms. M. Pachaji, learned additional senior government advocate, appearing for the respondents number 1, 2, 3, 4, and 5. Also heard Mr. A.I. Uddin, a learned counsel, appearing for the respondent number 6. We'll send it to the director. The petition, by way of instituting the present petition, has presented a challenge to the appointment of the respondent number 6, effected while order dated 3/1/2016 as Anganwadi worker in Panch Bhandar, Anganwadi Center under ward number 7, Ujai, Nagaon. Also, the petitioner, in the writ petition has projected that she was engaged as an Anganwadi worker, Anganwadi helper in Panch Bhandar, ward number 7. When were you appointed?
Appointment order is
What?
11/6/2007.
On 11/6/2007. She projects that in terms of the policy decision arrived at in the matter, the petitioner is entitled, considering her length of service as well as educational qualification for being considered for promotion to the post of Anganwadi worker, which is available in Anganwadi centers situated within the village wherein the Anganwadi revenue village wherein the Anganwadi center of the petitioner is so functioning, is so situated. Petitioner submits that she had approached the respondent authorities for consideration of a case for promotion. However, the respondent authorities proceeded to effect an engagement in respect of the vacant post of Anganwadi worker available in the Anganwadi center wherein the petitioner was working by way of direct recruitment. Also, she submits that on conclusion of the process involved, the respondent number 6 was wide order dated 28/11/2014. Engaged as Anganwadi worker of the said Anganwadi center. Wide an office order dated
The result sheet is a 3/1/2016. Page 29.
Where do I get it?
29.
There is no order brought on that. When were you appointed, Mr.?
They mean 2016, my lord.
Page 16.
Nothing is there, but it is sometime in 2016, 3/1/16.
In the year 2016. Also, the petitioner being aggrieved by the appointment and also on finding that and also by raising an allegation that the respondent number 6, who was appointed as an Anganwadi worker in so-and-so Anganwadi center, was not a resident of the area, of the coverage area of the said Anganwadi center, had approached the respondent authorities praying for interference with the said appointment of the respondent number 6. The same not being considered, the petitioner had instituted the present writ petition. Also, the learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner had prayed before the respondent authorities for conducting an inquiry to ascertain the residential status of the respondent number 6 and thereafter to take appropriate steps in the matter. Also, he submits that in the event the petitioner is, and the respondent number 6 is not found to be a resident within the coverage area of the Anganwadi center on the date of a such engagement, such appointment would be mandated to be set aside and the post and the resultant vacant post be filled up by considering the case of the petitioner herein for promotion. Also, per contra, Mr. A.I. Uddin, learned counsel for the respondent number 6 has submitted that the appointment of the engagement or initial engagement of the petitioner as an of the respondent number 6 as an Anganwadi worker in the said center was in pursuance to a due process of selection, and therein the respondents had ascertained the fact as to whether the petitioner belonged, as to whether the petitioner fulfilled the criteria of being a resident within the coverage area of the Anganwadi center in question. Accordingly, he submits that the claim made by the petitioner in the present petition would not mandate an acceptance from this court. Ms. Ms. M. Bachaji, learned additional senior government advocate appearing for the said of the respondent, submits that the petitioner has raised an issue of with regard to the residential status of the petitioner and has projected that the petitioner, respondent number 6, is not a resident within the coverage area of the Anganwadi center in question, which has been disputed by the counsel for the respondent number 6. Accordingly, she submits that in view of the disputed question of fact coming on, in view of the dispute regarded arising in the matter, this court would be pleased to refer the direct the director of what is that now? Social
Women and child.
Women and child. This does not come into my mouth. I don't know why. Women and Child Development, Assam, to inquire into the same and pass an appropriate order. So I've heard the learned counsel for the parties and also peruse the materials available on record. So from the materials, it is to be noted that neither the state respondents nor the respondent number 6 have filed an affidavit in the matter. So the petitioner in the writ petition has contended that the respondent number 6 was engaged as an Anganwadi worker in Panch Bandhar Anganwadi center. However, she was not eligible for being so engaged in as much as she was not a resident within the coverage area of the Anganwadi center in question. The issue arising in the present writ petition being with regard to the residential status of the respondent number 6, in an absence of any material being brought on record by the parties to the proceedings to arrive at a definite conclusion with regard to the same, this court would not proceed further to examine such disputed questions of fact. Also, however, considering the prayer of the petitioner that she is questioning the residential status of the respondent number 6 in the matter, this court directs the petitioner to file a representation with requisite materials before the Director, Women and Child Development within 15 days from today, and therein dispute the residential status of the Respondent number 6. The Director of Women and Child Development, on receipt of such representation from the petitioner within the time 1 month, within the time frame set out herein above, shall schedule a date of hearing and thereafter issue notices to the petitioner, the respondent number 6 and the Child Development Project Officer, Jurisdictional Child Development Project Officer, and full stop. Thereafter, after hearing the petitioner, the respondent number 6 and the Jurisdictional Child Development Officer, and also after considering the materials coming on record, determine the residential status of the respondent number 6. Full stop. On such determination being made, the Director shall pass a speaking order and communicate the same to all concerned, including the petitioner and the respondent number 6. In the event the respondent number 6 is found to be a resident within the within the coverage area of the Anganwadi center in question on the date of her initial engagement therein, no further order would be called for. Such engagement will not be mandated to be interfered with. Also, mandated to be set aside with. However, in the event it is ascertained that the petitioner on the date of her initial engagement was not a resident within the coverage area of the Anganwadi center, the Director Social Welfare shall, Director Child and Women Development shall pass appropriate orders directing for termination of the engagement of the respondent number 6 and thereafter proceed in the matter for effecting further engagement against the said post in accordance with law, and also take into consideration the claim of the petitioner for being considered for promotion against the said post. The entire action, the Director shall initiate and conclude the exercise as now required to be so carried out within a period of 3 months from the date of receipt of a certified copy of this order, along with the representation from the petitioner. With the above observations and directions, the present petition stands disposed of.
Page 12, my prayer portion, my lord. Small honorarium was left to be paid for a period, my lord.
That you come by, you put it there. Upar likha chu. What likhi do you? A representation, huh? Submit a representation disputing the residential status of the petitioner, as well as claiming honorarium which is in arrears.
Bless.
After vacation.
This passes all right.
Lord, I have seen the last query made by the court. Here, so far LIC is concerned, they are free. Now, so far the scheme is concerned.
Now tell me, Mr. Bhatt,
Yes, sir.
they say they have adopted ROP 2017. In the office, people, they were given the areas from which date.
I think my lord, the revised pay scale that
Was effective from which date? When was it made effective?
My lord, my clients have given a document of 3/8/2017. That's why that last order your lordship has made the query. 21/1/2016, where the revised pay has been done. But my lord, so far the scheme is concerned, as per the scheme, it will be applicable from 2016. Now, only initially
2016 for the general government employees.
Yes,
It will be applicable to you only on adoption.
that has been done. That
Adoption, but which date?
yes, my lord. It was adopted.
Adopted, that notification is there.
No, resolution
Resolution of the board is there.
at page 31.
31. But that does not give any date. And if we take it as 17/6/2017,
But-
there would be a number of your clients who would be out of the purview.
No, my lord. You said the board approved the proposal of payment of revised pay to household as per ROP
2017.
17.
But when was it implemented?
But if your lordship looks into the scheme,
We are not
Ah,
concerned with the scheme because the scheme is not applicable to you. Mr. Kumar?
Yes, my lord. This salary certificate, your lordship may kindly
Hmm.
look into it.
Yes, madam. What is your
Lordship,
instruction?
My senior is currently on legs, so he
Motion
allowed me to
Currently,
pass it
okay,
on.
no problem. So you mean to say that the people were given the areas from 1/4/2016?
I have, yes, but I have to again take, this was given to me. I did not had the occasion to talk with them. So I would also have,
So barring two of your petitioners who retired prior to that, page 111. Now, Mr. Kumar,
date of retirement, my lord, all is 2016.
Only one.
No.
2016. Others are 17.
1/4/2016, sorry.
Yeah.
1/4/2016, sorry. Did you get the revised pay?
That they have given me and left it in my junior in the chamber. I have to get it confirmed, my lord.
You get this confirmed.
Yes.
We'll have it after some time. Let's see what Mr. Bodloy, you need not be here.
Yeah. My lord, but I'll pray, my lord. I have looked into the.
And another thing you got
Yes.
to
Yes.
satisfy this court or argue before this court. What was adopted was the pay scale.
Yes.
What was adopted was the pay scale. If you see the resolution also, page 31. Here only the pay scale was adopted. If you read that page 31,
Yes, my lord, I have seen. Now, when you say it is revised pay,
revised pay, because Mr. Moore,
yes, my lord. Now, whether pay will include the gratuity
no,
or
it cannot be. Gratuity is different. Gratuity is there in another provision in that ROP rules.
Yes.
7 to 15. Now you have a definite system in your organization that
yes.
gratuity, leave encashment we will pay in terms of the policy of the LIC will do it. In government, the government pays. Now whether we can saddle the respondents elsewhere with the enhanced gratuity, enhanced leave encashment.
Your lordship will look at page 28, the debt cum retirement gratuity provision.
I got it. That is not your scheme. That
But
is
your
the
lordship
scheme
will
of the
say-
government.
The limit of debt cum retirement has been enhanced from the
Mr. I got it.
Yes.
This is a office memorandum issued prior after the adoption of the ROP rules.
Yes.
What is adopted by the organization is only the revised pay.
Yes. That we have to look into, because if
That-
you don't adopt it, then you are out.
Because other than this, there is nothing.
Yes, madam.
So
you
if
don't,
that be so,
Ah.
then it will fall back then coupled with the fact that how they pay.
yes.
They pay it through LIC.
That once I can satisfy that this has been adopted or gratuity, or this gratuity is covered by this scheme, then this liability of the, whether it is a house paid or LIC, it doesn't matter to me. But I have to
That
first
was my
show.
thought process.
Yes.
That was my thought process.
Yes, madam.
But you learn daily.
Yes, madam.
So yesterday when I was going through,
Yes.
when I read this,
Yes, madam.
and I read it does not refer to the OM dated 12/7. It
Yes.
refers to the ROP rules.
Yes.
ROP rules says ROP rules has many facets.
Yes, madam.
What has been adopted is only the revised pay.
And it has to be adopted. Otherwise, I will not be entitled.
Board approved the proposal for payment of revised pay to house.
Yes,
So revised pay is
Your lordship,
one
that-
aspect.
Yes. Your lordship is absolutely right, because this is again another statutory undertaking. They have to, unless it is adopted, the benefit will not accrue.
So as a senior counsel,
Yes, madam.
what is your take?
Madam, I have
Not as
to-
a counsel for
No. That's why I have
that we
taken.
can ask Mr.
Yes. I
We
have
can ask
taken
Mr.
out.
Kumar that. That's why we are asking.
Yes, madam. I have taken out judgment which are in favor of me. I have taken out judgment which are against me.
All judgments will boil down to this.
Yes.
If this fact, you can enlarge this
Yes.
page
That we
31.
have done innumerable cases on this point, my lord, because the moment you retire, on that day, whatever is due, it will count from that hour. not afterwards. I'm not telling about the day also, I'm telling about the hours.
No, Mr. Kumar, what was given to you, if it was only the revised pay,
Yes.
the other things will not come.
No. It will require some rethinking on my part because I have to look into, because this
Okay.
subsequent resolution of 28 and
But-
all.
Mr. P.D. Kumar, Learned Counsel, at some length. A query was raised by this court as to whether the adoption by the board of the respondent number of the respondent, Assam State Cooperating Housing Federation of the proposal for payment of revised pay to housefed employees as per ROP-2017 in its meeting held on 17/6/2017 would also bring within its fold the other benefits which is available to state government employees under the provisions of the ROP Rules 9/2017. Mr. Kumar fairly submits that he would have to examine the said matter in details and Mr. Kumar submits that he would examine the matter and apprise this court of the apprise the court of the same. Accordingly, a registry to list this matter again on
First week of May, my lord, any date convenient, my lord.
why not April?
April, my lord, most of the time I will be out, my lord.
On 06/20.
06, I think it's counting in Assam.
We'll have it on 2/6/2026.
2 is, my lord, Saturday, my lord.
No.
2/6.
2/6.
Oh.
It's a
Yes,
Tuesday.
Yes, 2/6.
We'll see. But take
Yes,
your
madam.
take on that.
Because I also have to, but I think your lordship is on the right track because that was also what I think. That's why I was looking into that whether I can.
You be the
include-
blocking stone. Take me out from my right.
Yes. Malab, there are another 2 items also. That also will require some rethinking.
Which one?
Item 14 and 15 of today's list, malab. That is in regard to parity of pay and all. I was looking into this, could not go through that file, malab. That your lordship may fix it in the first week of May. I'll, if there is case, otherwise no use keeping a date or.
Inform the PDCL authority.
Yes, madam. Your lordship will kindly accommodate me.
Let Ms.
Yes,
Kumar be here.
yes, please. I'm obliged, madam.
The better part of yours be here. You can go.
She has deserted me so far this case is concerned. So said that you apply your mind. So in the morning I was looking into it.
Desertion is only to a case. No
Yes.
problem. We'll ignore it.
Give them-
Just reiterate that prayer.
Yes.
I have to take time in this matter, my lord. I have to take time in this matter, my lord.
Wait.
So in this case.
Mr. Kumar took time, but he gave me a very good reason for that. I was blocked. I had to give time. Now you take a ground why I should adjourn this one.
My lord, because my lord, in this case, my lord, my friend, my lord, JUNM law score is also with me, my lord. And
If the AM or we is here, we are enough.
that was one of the brief fact I know.
A brief fact, you tell me, I'll consider.
Here in this case, my lord, in a my lord, first.
You are ready?
Lordship.
First selection process, my lord. Lord, this humble petitioner before your lordship was found, my lord, exclusively, my lord, eligible one candidate for one center, my lord. But in the meantime, my lord, they issued another advertisement, my lord.
Give me the dates of the advertisement.
And, this is the problem, my lord.
Okay, we'll take it up after 10 minutes. You read the file. None appears for the petitioner on call. Ms. M. Bachaji, additional senior government advocate, is present for the respondents. It is seen that on the last date of listing, that is on 4/1/2021. Also, there was no representation on the part of the petitioner. Also, considering that the petitioner continues to be unrepresented even today when the matter is called up, this court is constrained to draw a presumption that the petitioner is not desirous to further press the present petition. So accordingly, for the above reasons, the present petition stand dismissed for
Lordship, as per our instruction, she is not even qualified, Lordship.
that HS. But
And
She
Lordship,
tell-
there is a stay in this, Lordship. Kindly allow us to order dated.
interim orders passed earlier to stand vacated, stands vacated.
Lordship.
Here the case was first there was thing.
Yes,
You
Lordship.
cancelled it. She
Yes.
came before this court.
Yes, Lordship.
This court did not uphold, did not reverse the cancellation. It
Yes,
said
Lordship.
go ahead. So that
But-
is the place
but
wherein the right of the petitioner with regard to the first selection
Yes, Lordship.
extinguished.
Yes.
Subsequent selection, now you have issued an advertisement.
Yes, Lordship.
You have brought in the HS qualification,
Lordship.
which is in terms of the regulation policy you have.
Yes, Lordship.
Can she contest that?
Deeply obliged, Lordship.
Absolutely. Before I do it, I go through. If there is some material, we will pass some orders. There is nothing. Why should I waste my time? Ask my stenos to pass orders, right? Type out orders. None appears for, not like it was second round of material. Ms. James Learned Counsel for the petitioner submits that she be granted further 2 weeks' time to complete her instructions as well as to complete her instructions and make her submissions in prayer. Prayer is not objected to by the Learned Counsel for the respondents. Registry to list this matter again on 7/5/2026. No further adjournment shall be granted in the
Obliged.
My lord,
Yes, Mr. Dingya.
my lord, in this case, my lord, out of two, my lord, grievance of the petitioner, my lord, one grievance already fulfilled, my lord, during pendency of this case, my lord. He was promoted to the next post, my lord, SI, my lord. But only, my lord, since, my lord, he was not promoted in due course of time, my lord. The financial.
You're still working.
Yes, my lord. My lord, he is genuine income.
Okay. Who are the juniors who were promoted?
My lord, actually, one is Rajan Singh, my lord.
So you have a particular date from wherein you are claiming your promotion. You have persons, purportedly junior to you promoted. Where are they? Where are they before us?
Yes, sir.
You've got your promotion, that's and we can't even think of retrospective effect because you are not there. You say that the respondents have regulated the promotions in a particular manner. Constable, Nayak, Lance Nayak, then Havildar, then SI or ASI, whatever it is. So you are proceeding in that line. Some others who have come in subsequently were directly promoted as not as Lance Nayak or Nayak or Lance Nayak, as ASI and then as SI. Now, who are those people? How were they promoted? When did they come in? Where are those particulars?
Representation, my lord, the petitioner.
Their representation is nothing. And the rules does not support your case. You got your relief. I think you should withdraw this. Nothing is left. We can't consider. We'll have to dismiss it. And we'll take your cost, a rental for keeping this file here for such a long time. We'll take a rental for that. Mr. Ellen Dingya, Learned Counsel for the petitioner, submits that the petitioner during the pendency of the present petition has been favored with the promotion, has been granted his promotion to the post of sub-inspector.
Sub-inspector.
Sub-inspector bracketed motor transport in Sahastra Sima Bal. So he submits that the petitioner's prayer, further prayer. Accordingly, he submits that the prayer of the petitioner to promote him to the post of sub-inspector, motor transport as made in the present writ petition stands redressed. We have not even made a pair for retrospective effect here. Come to your pair, page 12. So accordingly, the prayer of the petitioner for promotion to the rank of sub-inspector having been granted to him during the present writ petition, this court is of the considered view that no further live issue arises for consideration in the present writ petition, and accordingly, the same is closed as having become infructuous. Era kam korason. What ta likhiba? The etul Ellen Dhiyan likhila to. The petitioner has instituted the present writ petition praying for the following relief. A to A. Mr. Ellen Dhiyan, please, page number 12. A to A.
My lord, liberty may be given, my lord, to file my case, my lord.
Oh, what? Liberty to challenge something which has happened in
Representation was filed, my lord.
representation is nothing. If you want to argue, I'll dismiss that.
Please, your lordship. Hearing your lordship, my representation dated 2011-2019.
This is under the 2011 rules.
Under the 11 rules, now it will be 2018 because the 11 rules has been struck.
So you are giving up your claim for of the 11 rules.
11 rules have been.
Now you have been, who is the private respondent?
And for the college.
Private respondent is working
My lord,
from 11.
2014 million.
From 2000, that's under the 2011 rules. So you are giving up the challenge to that. Shall I record that?
Yes, but in regard to 2018 rules, now I filed a representation earlier. That was also disregarded by the respondent.
We'll come to that. But your first claim is in the writ petition, you filed writ petition without impleading the respondent number 6. Respondent number 6 filed a writ petition impleading you. Therein this court had come to certain conclusion by which the respondent number 6's provincialization was upheld.
Okay.
So you are out. So, but you have again here challenged that.
Yes.
Right?
Yes.
This order was not six.
Oh no, it's only 2017.
2017, but it should be 2018 because
18, okay, fine.
Yes.
But you want a seniority over the respondent number
Over the
6.
respondent.
That cannot be.
But as per the rules, I'm senior.
How? He is already provincialized in 2011.
2014.
You are not provincialized under 2011. So he is a government servant prior to you. You are not still a government servant. If you become also, you will be from the date the 2018 Act has come into being, not prior to that. So how will you, what is the comparison? Nothing.
I have been working since 2000.
That is gone. That is gone. You were in the arts section. I don't know how this distinction was made, arts, commerce, science. But be that as it may, that has attained finality. And where is your rejection of your this 2018 thing?
2018, I filed the representation.
No. The government has taken a call.
The rejection of the representation is page
Where?
76. Last page.
76, yes, is the.
Just now. This is only with regard to the objection in under the, with regard to Ajit Bhuya. Mr. Bora, you are appearing for Ajit Bhuya. You are continuing. You have not yet. Here there is nothing with regard to 2017.
With regarding 2017, I have filed the representation that is at page 72.
Only
73, the relevant portion. I stated that as 2017.
Has the arts section been now provincialized?
Yes, that has been provincialized earlier.
Way back, my lord, since 1970.
73 only it was
Okay.
provincial.
Science was
Science was-
provincialized now.
Later.
Later on.
His appointment was against the science.
Yes, Mr. Das. You will have to
Madam.
consider him in terms of that 2017-18 Act. 18 Act, sorry, that ministerial stuff.
Ministerial. My lord, this the speaking order which has been challenged by
Speaking
the
order
petitioner,
is
that is, my lord,
the 2011 Act only.
yes, my lord. So in this petition, my lord, the petitioner doesn't have a case, my lord.
No,
Because-
he has only made a prayer that consider my case
And kindly see the
as,
prayer.
as 2017, but make
No,
me senior to respond number 6. That we will reject.
Kindly see the prayer of the representation, my lord, page
Huh.
73. It is prayed therefore that your good self shall consider this representation and for ends of justice keep the matter of service of junior assistant of the science stream of so and so in abeyance till the decision.
But he is praying for a direction. You just see.
of the-
As per the provisions regarding provincialization of the petitioner and Ajit Bhiya,
my lord.
as per 2017, we will not touch Mr. Ajit Bhiya's provincialization. We'll only say that is beyond. If you want that, I can pass that order.
That direction.
Authority will see, my lord.
That
after
2017, he will file a fresh representation
lord.
only with regard to 2017.
2017.
Nothing to do with Ajit Bhiya.
Yes, my lord. And authority will check whether
As
he
per
is,
the act, if
yes,
it
my
is
lord.
found eligible, go ahead.
Yes,
Within a period of 6 months, take a call.
yes.
Otherwise, your lordship, regarding Ajit Bhuya, his appointment is also illegal as because the 2011 act has been struck down.
Okay, argue.
No, no, I'm just saying.
That order was
That issue has been settled, my lord.
Let him argue. The young counsel is entitled to argue. You all take your seat. Yes, Mr. Doctor, argue.
Your lordship may see this education, Assam education non-teaching staff and
No, first give me the facts.
facts. Your lordship, first of all, I joined the post of LDA in the THB college on 31/7/2008.
That's not so.
Thereafter, the respondent 6, he was appointed on 31/8/2009.
This is against a non-sanctioned post.
A non-sanctioned.
You were in the arts section,
I was in the art section.
which was already provincialized.
That was already provincial. And then in the year 2011, the provincial
Where is your appointment order?
appointment order, your lordship will find at page 41.
Then what happened?
Then the respondent number 6, he joined
When?
in the post of LD on 31/8/2009.
31,
8/2009.
respond number 6.
Respondent 6.
But he joined against the science section,
No, he also joined against a non-sanctioned post.
non-sanctioned.
Yes.
Where is that order?
That order, they have annexed it in their affidavit. Lordship will find that at page 97.
That is an
Is
advertisement.
the 97 is the advertisement. Appointment. Let's see.
No appointment order.
Appointment order has not been.
Okay. Resolution is dated 10/9. It says science stream.
Science stream. Now, in the year 2011, the provincialization exercise began. So the college authority had submitted the list of teaching and non-teaching staff to the DHE.
Where do I get it?
That your lordship will find at page 51. Page 51, your lordship will find the non-teaching staff. The serial number 1, my name is there. Sanjeev Das. The date of joining is shown as 31/7/2008. And then respondent 6, Shri Ajit Bhuya.
Then what happened?
Then the respondent 2, your lordship will find in the next page. They have also issued this list of provincialization, where at serial number 10, page 2, your lordship will find that Ajit Bhuya's name has been shown as qualified.
Is number 50?
52. And page number 54, your lordship will find my name at serial number 7.
Qualified leave.
Which has been shown as disqualified. Now, as per the rules, there is no such requirement that non-teaching staff should be from a particular stream of arts, commerce, or
Then
science.
you came up before this court.
Then I came up before the court, and your lordship will find the order passed by this court at page 56. The operative portion will be 59. The court directed me to submit a representation before the respondent 2. On this, page 59 and 60. Then, as per this order, I filed a representation before the respondent 2 at page 61. Thereafter, respondent 2 forwards the letter to DSLC, which your lordship will find at page 64. I'll read that minutes. Lordship may come to paragraph 1. The third paragraph, which starts with, it is true that the petitioner is senior to the respondent number 5, Ajit Bhuya, by more than 1 year, 1 month. Moreover, the petitioner has been performing his duties sincerely and with utmost satisfaction of the college authority since his joining, as stated by the principal of THB College. Further, the appointment of Sri Ajit Bhuya did not state that he was appointed in the science stream, as claimed by the respondent number 5. Section 4.2.10.4 of the 2011 Act does not indicate that LD assistant, junior assistant has to be from a particular stream. After considering the above facts and documents, the DSLC has put its conclusion in favor of Sanjeev Das, the petitioner, and the services perhaps may be provincialized as per 4.3 of the 2011 Act. So thereafter, I was provincialized, and then respondent 6 came up with writ petition 399 of 2017. which your lordship will find at page 65. Page 67 will be the operative portion. Page 67, your lordship will come, the operative portion.
Give me 2 minutes.
Your lordship may come to 67, page 67 of the order.
We have got it. We have got it.
So the honorable
It was
court-
that such recommendation by the DSC under the 2011 Act
Yes.
was not permissible.
Yes.
Oh.
As because the act was struck down. So thereafter, I filed a representation to the DSLC, page 69. That my representation should be considered in terms of the 2017 Act, which should have been 2018. Thereafter, as this prayer was not considered, I preferred another writ petition. Which
That was,
that was
you go to the tribunal.
yes, yes. At page 71, you will find that. Thereafter, I filed another representation before the DHE at page 72 and 73.
What is this date?
The date will be 4/10/2019.
What is your prayer here?
To consider, shall consider the representation, keep the matter of service of junior assistant so and so. In a
District level tribunal, you had approached the tribunal also?
I have not probably filed the case before the tribunal, but I thought of filing.
Then what happened?
Then I filed. Then this representation that was disposed of, that was rejected by the DHE by this impugned non-speaking order at page 76.
But this court, while interfering with your, what did you say, DSC's recommendations, did not say that the appointment of the respondent number 6 would also be not permissible. He had already joined. So that matter had got a closure. Now, how can we rake up that matter now? Because the earlier direction is against you. You have not even carried up it on appeal.
Yes, that is.
So to that extent, that order stands. Now, whether you are in the art section or the science section, mind you, they think properly and give me a reply. Whether you are in the art section or in the science.
I'm in the art section.
Art section. Yes. Art section was provincialized when?
1963, 72.
So we note that you are You are making a submission that you are in the arts section.
Yes, yes, that is admittedly true.
And the petitioner was in the science section.
Yes.
Now let us see the 2018 Act.
I have a copy of that.
That's okay. 87.
So, your lordship may come to
Section.
Rule 4, non-teaching staff to be government servants. The proviso will be important.
Some substances.
Now, Mr. Das, come to, Doctor, come to 3, section 3. Read that.
Yes, eligibility criteria. Subject to provisions of Article 30, the venture education institution which have been considered for provincialization of service of teachers, tutors under the Assam Service of Teachers Act 2017 shall be eligible for being considered for provincialization of services of their non-teaching staff.
So, to come within the purview of 2018 Act, your institution must be within the purview of the 2017 Act. Now come to the 2017 Act. Come to section 3.
Yes, your lordship.
There is a bar here somewhere. Just forgot that. Mr. Das, where is the bar? That if the institution is provincialized under any other act, then the employees will not be barring the 2011. There is some provision. You are a venture degree college.
Yes.
Come to 2W.
Of the 17 Act.
of the 17 Act. 2W, Venture Degree College.
Yes.
Means a degree college imparting education beyond higher secondary stage, established by the people of the locality prior to so-and-so, which has also received affiliation from the concerned university, concurrence from the state government, on or before so-and-so, at least for so-and-so, and whereof the services of the teacher has not been provincialized under any act enacted by the state legislature so far. So, your stream, it was a government college, government provincialized college. Since
1974 it was
74. Provincialized in 1974. So, you don't come within the purview of 2011. You don't come within the purview of 2017. They're not entitled under either. Because under 2018, if you have to be entitled, you will have to be eligible under, I'll not use the word consider, college consider, but you will have to be eligible under 2018, 17. Not eligible under either. Is that the correct position, Mr. Katonier? Huh? So, you admit that you are a science, arts, you were arts in the arts college. Arts was a provincialized college already. Science was a addition to that. It also got provincialized. Maybe now it is one unit. One unit now?
Yes.
Now it is one unit. But you not being there in the science, you not being within the purview of 2017. And that is why they said arts stream disqualified. You're not entitled. Mr. S. Doctor, after submitting the matter at some after making his submissions on a query being raised by this court as to whether the petitioner being in the art stream of Yagbir Hemborua College, Zamuri Ghat, which stream was already provincialized way back in the year 1974, and claim for being considered for provincialization under the provisions of the Assam Education Provincialization of Services of Non-Teaching Staff of Venture Educational Institutions, as Act 2018, has submitted that he be granted some time to examine the said matter. They accepted. Also, the Learned Counsel for the petitioner as well as the Learned Counsel representing the respondents shall examine the above issue and address this court on the next date of listing. Also, registry to list this matter again on, I'll forget, on 7/4/2026. 7/4, huh? Any problem? When? Tell me.
On 6th.
6th, okay. 6/4/2024. 2026.
Obliged.
For further hearing. I sleep what I do.
Much better.
Hmm. Yes.
But initially,
Hmm.
one advertisement was issued, my lord, on 22/7/2023, my lord.
13.
2013, my lord, page 14, my lord, in this read petition.
Hmm.
Here, my lord, shortlist was made, my lord, on the basis of selection, and here, my lord, it was provided for oral interview, my lord. And here, my lord, that one Lilima Majumdar was not there, my lord, but petitioner's name at serial number, my lord, last one, my lord, Sajna Begum, my lord. But there are
Advertisement for Anganwadi work. Which
Work,
Anganwadi center?
yes, my lord.
Binakandi. No, Binakandi is the number 110.
Yes, my lord.
Singarbond Pattu. AWC. Then page 14 is the shortlist.
Yes, my lord. Here, my lord, she was not there. But in the interview found, my lord, she has come, my lord, one Lilima. Then present petitioner before your lordship filed one read petition, my lord, and read petition page 20, my lord.
Private respondent is number?
Here,
She's,
yes,
she's not a private respondent.
yes, my lord. In this read petition, earlier one, my lord, she was relevant, and page 20, my lord, her name is appearing at, my lord, as private respondent, my lord, 1, 2,
Name
3,
of Lilima.
yes, my lord, 6 Lilima, my lord. And read petition was disposed of, my lord.
No, one second. The name of the lady who was appointed is Lilima.
Not, my lord, appointed,
But appeared in the
contemplated-
selection was who?
Yes, my lord.
What is the name?
Lilima, my lord.
Lili?
Lilima Begum Majumdar, my lord. Page
Lilima Begum
14.
Majumdar.
at page 20, my lord, her name is, my lord, appearing
Okay,
as respondent.
not there. And your name is there at serial number?
No, my lord, she
14,
is.
14 serial number.
Yes, my lord. But her name is not there, but suddenly, my lord, he was.
No, Lilima is there. Lilima Begum Majumdar at page 14.
14.
14
11.
11.
Yes, my lord.
And where is your name?
My name is last one, my lord.
Sajana. Then what happened?
My lord, I approached before this honorable court, my lord, by way of read petition page 20, my lord. And this matter was disposed of to, my lord, consider and dispose of, my lord, representation.
You raised a dispute at page 15.
Yes, my lord.
That Lilima is not a resident of the area.
My lord. That representation was directed in the writ petition to be disposed of, my lord. Page 20 is the order, my lord.
Page 20.
Yes, my lord. It was directed to consider, my lord, that my complaint and or, my lord, representation dated 22/9/2000.
21 is the relevant portion.
Yes.
Then what happened?
Then, my lord, it was submitted before the concerned authority order of this honorable court. Page 22, my lord, it was submitted to the deputy commissioner, and page 23, another application by, my lord, was submitted to the child development project officer. The order passed by this honorable court, my lord.
Then what happened?
Then, my lord, final order was, speaking order was, in the meantime, my lord, I filed one contempt petition, and after filing the contempt petition, my lord, this page 26 order was passed, my lord. Page 26, order, my lord, relevant portion, my lord, page, precisely, my lord, page 27. It was provided that, my lord, in view of the above, since as.
Just a moment. She did not challenge this.
No, my lord.
Okay.
Then, my
To
lord,
take necessary steps as per in consultation with project level selection committee. Okay.
now, my lord, they admitted that part, my lord, in their affidavit in the contempt case, my lord, and with some, my lord, good observation, this contempt proceeding was disposed of, my lord, this
Okay,
order,
let us see the contempt
page
proceeding.
32, my lord. NHR 8. It was also provided that, my lord, in view of the above, this court is of the view that the order of this court dated so and so has been complied with by the Deputy Commissioner Kachar.
So what the court said was do as per the
Yes,
observations made in the
this report.
by the DC.
My lord. Now, my lord, subsequently, my lord, petitioner also submitted one representation, my lord, this is page 34. In the meantime, my lord, they issued one advertisement, my lord. Another advertisement, this, my lord, this is my grievance, my lord. They abandoned the earlier first selection process, my lord. Where was, my lord, conclusively this.
Where is the fresh advertisement?
My lord, this page 37, my lord. Then, my lord, then, my lord, this advertised challenge, my lord, then they assured us, my lord, they will give appointment to the petitioner, my lord. But it is not done, my lord.
No.
And I challenge this advertisement, my lord, and later with liberty, my lord, I withdrew this writ petition, my lord, this order at page 41, my lord. Again, now, my lord, they.
One second.
Writ petition is disposed of as withdrawn with liberty to file a fresh case if so advised. The petitioner should also be allowed to participate in the selection process. Interim order passed earlier stands vacated. Now, my lord, they, in the meantime, they issued third advertisement, my lord, page 43, my lord.
Now higher secondary.
Higher secondary.
And you are only a matriculate. So you are challenging this advertisement.
Advertise, basically, my lord, I am claiming my original appointment, my lord, because, my lord, everything was
No,
final.
where is that selection in your case? Where is your selection? You were only shortlisted.
Listed, my lord.
Then the matter went behind, then you went behind Lilima.
Yes, my lord.
That matter got
Result.
finished. Then you again filed a contempt.
My lord.
Contempt In the meantime, Deputy Commissioner passes an order. That linima cannot be considered. So act in consultation with the project level selection committee. Now, your contempt petition got disposed of, directing that now you act as project level. There is no order to carry forward the earlier recruitment process. Then again, you come up after they issue 1/1/2006. You withdraw it, saying that let me participate because I have already applied. That means whatever was there, gone. Now you participate, anything comes up, you can make a challenge. Then they issue that advertisement, unfortunately was not taken forward. You have not assailed that. You have not said that 1/1/2016 should be taken to its logical conclusion. Now you come to your prayer.
Yeah.
It was 2019.
Is therefore most respectfully prayed that your lordship would be pleased to admit this citation, call for the record issue rule calling upon the respondent to support by
Appoint the so-and-so. Appoint the so-and-so from where? Where is your selection for that appointment?
implement. Paragraph 9, my lord. Paragraph 9, my lord.
Of?
Read petition, my lord.
No, show me the prayer.
My lord, the prayer means, my lord, that.
Prayer is not there.
Prayer is, my lord, finishing part, my lord, but contention, my lord, grievance, my lord, page 9, my lord. Paragraph 9, my lord. But the petitioner begs to submit that once the selection was completed with the petitioner as ever advertisement of the year, but wrong.
Where was that lady appointed first place?
No, she was not appointed.
Then what is this?
Therefore, my lord, my case.
No, you have, Mr. This is not the way you draft a writ petition for the High Court. I'm sorry. I'm sorry. Your case should have been before this court that the process of selection that is kept in abeyance,
That should be continued.
that should have been continued.
Yes.
Now then they issue advertisement. You succumb to that advertisement, you participate, and then you pray
No,
before
Lord,
this
they
court
misstated,
kindly.
my lord. Therefore, my lord, therefore I took liberty, my lord.
What happened to that process is 8-2 also. You have not taken forward, Ms. Sharma.
Lordship, I have received one latest instruction.
Give me that. And don't file affidavits if you don't want to file. These are not the forms
Yes,
of
Lordship.
affidavit.
As per this instruction, Lordship, the petitioner has passed only HSLC
Fine, we
examination.
know that. Then what? What
And-
happened to 8/2/2019?
The petitioner has not applied against that advertisement.
What
Lordship.
happened to that advertisement?
An interview also has not been held. This is an instruction of 25th October 2024. There is a notification also, Lord. Lordship, one eligibility criteria number 4 of the notification. The candidate should have the qualification of HS, higher secondary.
This much will do. Yes, Mr. Borviya.
Yes,
How
my lord.
can we help you?
My lord. There, my lord, it was earlier time, she took time, my lord, to file another affidavit.
Forget the affidavits. Forget the affidavit.
Lordship, this is in pursuance to that order,
Okay.
Lordship, this instruction.
Heard Mr. A.M. Barviya, learned counsel for the petitioner. Also heard Mr. Ms. B. Sharma or Ms. U. Sharma?
U Sharma.
U. Sharma, learned government advocate appearing for the state respondents. The present writ petition has been instituted assailing an advertisement dated 8/2/2019 issued by the Jurisdictional Child Development Project Officer for the recruitment for engagement of an Anganwadi worker against number 110 Singar-Band Part -2 Anganwadi Center. Take your seats, take your seats. Also, the petitioner in the present petition projects that in pursuance to an advertisement dated 22/7/2013, she had submitted her application for engagement as a Anganwadi worker in 110 Singar-Band Part 2 Anganwadi Center, hereinafter referred to as the Anganwadi Center in question. Also, after the last date of submission of applications were over, the respondent authorities upon scrutinizing the applications received, prepared a list of shortlisted candidates, prepared a panel of shortlisted candidates, and therein the name of the petitioner, along with that of one Lilima Begum Majumdar figure. The said panel being published, the petitioner having learned that Lilima Begum Majumdar was not a resident within the coverage area of the Anganwadi Center in question, had approached the authorities praying for deletion of her name from the said panel. The said prayer not being considered, the petitioner approached this court by way of instituting a writ petition being WPC number 6478/2013. Ms. Sharma, we just see whether the facts somewhere.
Yes,
Yeah.
Lordship, I'm looking for.
So and so. The said writ petition was disposed of by a coordinate bench of this court wide order dated 11/11/2013, directing the respondent authorities to dispose of the representation preferred submitted by the petitioner as raising grievance against raising a dispute with regard to the residential status of said Lilima Begum Majumdar. The directions passed by this court wide the said order dated 11/11/2013 having not been complied with, the petitioner instituted a contempt petition being contempt case COPC bracket number 1199/2011. Also, during the pendency of the said contempt proceedings, the Deputy Commissioner, in terms of the directions passed by the order dated 11/11/2013, proceeded to examine the matter in terms of the representation submitted by the petitioner. And on such examination, having found said Lilima Begum Majumdar to be not a resident within the coverage area of the Anganwadi Center in question, proceeded wide order dated 8/9/2015 to delete the name of Lilima Begum Chaudhary from the panel so prepared in the matter. Also, it was further stipulated in the said order that the Jurisdictional Child Development Project Officer shall now proceed with the matter with consultation with the project level selection committee. Also, thereafter, this court had taken up the contempt case being COPC bracket number C number 199/2015 for final consideration and wide order dated 23/11/2015, noticing the order passed in the matter by the Jurisdictional Deputy Commissioner, proceeded to close the said contempt petition, directing the respondents therein to act in the matter strictly in terms of the findings of the Deputy Commissioner as recorded in the order dated 8/9/2015. Also, after the said order was passed by this court, order dated so and so 23/11/2015 was passed by this court, the jurisdictional CDP proceeded to issue a fresh advertisement dated 1/6/2016 for recruitment against the post of Anganwadi worker in the Anganwadi Center in question. Petitioner being aggrieved by the fresh process of recruitment initiated had assailed the same before this court by way of instituting WPC number 287/2016. During the pendency of the said proceedings, the learned counsel representing the then Director of Social Welfare Assam, having placed on record the application submitted by the petitioner in pursuance to the advertisement dated 1/1/2016, the petitioner prayed for withdrawal of the said petition with a liberty to appear in the selection process as would now be initiated in pursuance to the said advertisement dated 1/1/2000. This court-wide order dated 3/6/2016 permitted the petitioner to withdraw the said petition with liberty with further direction that the petition shall be permitted to appear in the selection process in question. The petitioner projects that without the respondent authorities not taking the selection process as initiated in the matter, while the earlier advertisement dated 22/7/2013 and of the advertisement dated 1/1/2016 to its logical conclusion have thereafter again on 8/2/2019 issued a further advertisement for the same very engagement involved in the earlier two advertisements. Also, the petitioner being aggrieved by the advertisement dated 8/2/2019 on amongst inter alia on the ground that the qualification now prescribed therein for such engagement being requiring a candidate to have the HS higher secondary qualification and she being only a matriculate, had instituted the present petition assailing the said selection process. So, Mr. A.M. Barbhia, learned counsel for the petitioner, has submitted that the petitioner being a shortlisted candidate in pursuance to the advertisement dated 22/7/2013, the respondents were required, respondent authorities were required to take the said selection process to its logical conclusion, and in the event the same was so done, the petitioner hearing would have been the petitioner hearing had a chance of being engaged as Anganwadi worker against the post advertised. He, however, submits that in spite of the repeated directions passed by this court in the proceedings so instituted by the petitioner, the respondent authorities have not taken the said process to its logical conclusion and have been issuing one advertisement after the other, and the post still remains vacant as on date. Also, in view of the above, in the above premises, Mr. Barbhia submits that that a direction be issued to the respondent authorities to conclude the selection process as initiated by the advertisement dated 22/7/2013 and thereafter to 13 by reckoning the eligibility criteria as mandated on the date when the said advertisement was issued and to take the process to its logical conclusion. That much only. Also, Ms. U. Sharma, learned government advocate, submits that the proceeding as instituted the recruitment process as instituted by the advertisement dated 22/7/2013, admittedly not being taken to its logical conclusion, the same having been superseded in pursuance to the having been superseded while the advertisement dated 1/1/2016, the petitioner cannot claim to cannot raise a claim for requiring a direction upon the respondent authorities to take the recruitment exercise as initiated by the advertisement dated 22/7/2013 to its logical conclusion. She submits that the advertisement dated 1/1/2016 submits that the petitioner in the present writ petition has not prayed for any direction requiring even the recruitment process initiated in pursuance to the advertisement dated 1/1/2016 to its logical conclusion. Also, she submits that the challenge in the present writ petition being only to the advertisement dated 8/2/2019, she by highlighting that the challenge in this so-and-so submits that the recruitment process initiated by the advertisement dated 8/2/2019 that in pursuance to the advertisement dated 8/2/2019, no selection process was initiated and the entire process was kept in abeyance by the project level selection committee by the project level selection committee, while a decision arrived at by it in its meeting held on 25/2/2019. She submits that the respondent authorities in the meanwhile had revised the selection criteria required to eligibility criteria required to be processed by a intending candidate for the post of Anganwadi worker and or Anganwadi help. She submits that in terms of the fresh guidelines now published wide notification dated 25/1/2019, a intending candidate amongst others is now required to possess a higher secondary qualification from the Assam Higher Secondary Education Council or a equivalent qualification from a recognized board council. She submits that in terms of the revised qualification eligibility criteria is now published, the respondent authorities would be required to issue a fresh advertisement in the matter by inviting applications from intending candidates with the revised qualification. She further submits that the recruitment process as initiated in the year 8/2/2019, having not been taken to its logical conclusion, many fresh candidates having now become eligible for being considered for engagement against the post in question, the said recruitment process as initiated by the advertisement dated 8/2/2019 would not mandate to be directed to be taken to its logical conclusion. Also, accordingly, she submits that the present writ petition would mandate a dismissal. Also, I've heard the learned counsel for the parties and also perused the materials available on record. The facts noticed herein above are not in dispute. The petitioner, although had not prayed for the said relief, the learned counsel for the petitioner during his submissions had submitted that this court would be pleased to direct the respondent authorities to take the recruitment exercise as initiated in pursuance to the advertisement dated 22/7/2013 to its logical conclusion. Also, this court has, for the purpose of examining the said prayer of the petitioner, has perused the materials available on record. This court finds that the petitioner not having petitioner's applications, petitioner's representations disputing the residential status of said Lilima Begum Chaudhary Majumdar having not been considered, had approached this court by way of instituting a writ petition being WPC number 6478/2013. This court, while ordered it 11/11/2013, had disposed of the said representation, requiring the jurisdictional deputy commissioner to consider the representation as submitted in the matter by the petitioner and to pass an appropriate order in the matter. Also, the said representation having been not considered, the petitioner had instituted a contempt petition being contempt case number PC number 199/2015. Also, however, during the pendency of the said contempt, The Jurisdictional Deputy Commissioner, wide order dated 8/9/2015, proceeded to consider and dispose of the representation preferred by the petitioner by holding that said Lilima Begum Chaudhary was found to be not a resident within the coverage area of the Anganwadi center in question. Having drawn the said conclusions, the Deputy Commissioner proceeded to direct the Jurisdictional Child Development Project Officer to take necessary steps in consultation with the project level selection committee to take the matter forward. This court thereafter considered the contempt case number so-and-so, contempt petition filed by the petitioner and wide order dated 23/11/2015, noticing the findings recorded by the Jurisdictional Deputy Commissioner in his order dated 8/9/2015, proceeded to dispose of the said contempt petition, holding that the directions, violation of which was alleged therein, stood complied with, and with a further observation that the Jurisdictional Child Development Project Officer shall now take consequential steps on the basis of the findings recorded by the Deputy Commissioner in his order dated, in the said order dated 8/9/2015. Thereafter, it is seen that the petitioner herein, thereafter, on a fresh advertisement dated 1/1/2016 having been published, for initiating a process of recruitment to the post of Anganwadi worker in the said Anganwadi center, the petitioner assailed the same by way of instituting WPC number 287/2016. However, during the pendency of the same, the petitioner did not proceed with the said challenge and prayed before this court for permission to withdraw the said writ petition, with a further prayer to allow her to participate in the selection process, as per the impugned advertisement dated 1/1/2016. This court, wide order dated 3/6/2016, allowed the prayer of the petitioner. The observations made by this court, wide the order dated 3/6/2016, being relevant, is extracted here in below, page 41, A to A. A perusal of the said observations would reveal that the petitioner had given up her grievance with regard to the recruitment process initiated while the advertisement dated 22/7/2013 not being taken to its logical conclusion, and had now limited her grievance to the recruitment process that has now been initiated while the advertisement dated 1/1/2016. Accordingly, in view of the observations as contained in the order dated 3/6/2016, it would not be, this court is of the considered view that it is not permissible to the petitioner to further pray for continuance with the, for taking the recruitment exercise as initiated while the advertisement dated 22/7/2013 to its logical conclusion. Also, further, this court further finds that in the present writ petition, the petitioner has not prayed that the recruitment exercise as initiated, even while the advertisement dated 1/6/2016 also should be taken to its logical conclusion. 1/1/2016 should also be taken to its logical conclusion. Also, accordingly, in absence of a prayer being made in this connection, and also no contention also being raised in this connection in the writ petition, this court would not be in a position to direct the respondent authorities to take the selection process, a recruitment exercise as even as initiated by the advertisement dated 1/1/2016 to its logical para. Having drawn the said conclusion, this court would now examine the challenge presented by the petitioner to the advertisement dated 8/2/2019. The materials brought on record. This court at the outset notes that from the materials brought on record, the advertisement dated 8/2/2019, in terms of a decision arrived at in the matter by the project level selection committee in its meeting held on 25/2/2019, was kept in abeyance. Also, no selection process in pursuance to the said advertisement having been found to have been initiated for the last around 7 years. This court is of the considered view that at this present stage, it would not be permissible to direct the respondent authorities to take the selection process as initiated by the advertisement dated 18/8/2019 to its logical conclusion. Also, in this connection, this court has appreciated the submissions of Ms. U. Sharma that after the issuance of the advertisement dated 8/2/2019, many other candidates would have also acquired the eligibility for applying for the post of Anganwadi worker in the Anganwadi center in question. Also, this court further notices that the respondent authorities provide a notification dated 25/1/2019, that is, prior to issuance of the advertisement dated 8/2/2019, had revised the eligibility criteria for recruitment for engagement as Anganwadi worker. The earlier guidelines had mandated an intending candidate to possess a matriculation qualification along with a matriculation qualification for the purpose of recruitment to the post of, for the purpose of being eligible for recruitment to the post of Anganwadi worker. However, while the notification dated 25/1/2019, the said qualification has been amended and presently an intending candidate for the post of Anganwadi worker in an Anganwadi center and a worker in a mini Anganwadi center should possess the qualification of higher secondary pass from the Assam Higher Secondary Education Council or a equivalent qualification from a board/council recognized by the government of Assam. The said guidelines having revised the eligibility educational qualification for the post of Anganwadi worker, this court does not find any error on the part of the jurisdictional child development project officer in issuing the impugned advertisement dated 8/2/2019 by prescribing therein the educational criteria as eligibility, that as by prescribing therein the educational qualification requisite for a candidate to apply in pursuance thereof as HS pass. Also, accordingly, the said advertisement would otherwise not have mandated interference from this court. Also, however, considering the long lapse of time occasioning since the date of issuance of the said advertisement dated 8/2/2019, also considering the fact that many other candidates would have now become eligible for, would have now acquired the eligibility for applying against the post of Anganwadi worker in the Anganwadi center in question, this court is of the considered view that there would that it would not be mandated to direct the respondent authorities to take the process of recruitment initiated by the advertisement dated 8/2/2019 to its logical conclusion. So the respondent authorities, Ms. U. Sharma, on instructions had submitted before this court that there was no selection process initiated after the advertisement dated 8/2/2019 till date. Also, accordingly, the advertisement dated 8/2/19 is set aside. The respondent authorities are directed to initiate a process of recruitment or engagement of an Anganwadi worker against the Anganwadi center in question by following the procedure mandated for such selection and by prescribing eligibility criteria in terms of the guidelines for such engagement currently in vogue. Also, with the above observations and directions, the present petition stands disposed of. Sorry. These cases, it kept pending. I'll have to take rent from you.
Obliged, Lordship.
None has appeared for the petitioner, even on second call. So accordingly, the present writ petition stands dismissed for non-prosecution. All who can use it. That was it. Yeah, no. They act number 2. No proceeding against her, against him after this. Your director is not even in a position to take a call. But everything is written there, but he is not entitled. Now, what is the fault? First, you bring him. Seeing her, I am saying her. Just recapitulating the facts so that I can dictate. You bring her to town Panigaon ME school in Nagaon, right? Thereafter, if I miss out the sequence, just tell me. Because you appreciated the fact that he is suffering from some problem and that school is very far away.
And medical board also says I'm suffering.
That is subsequent. Oh, I'll forget the sequence. Wait. Then what happens is that the school gets amalgamated with the high school. And before all this, there are proceedings before this court because you wanted her to go back. Then she comes up and then you direct that this court directs for consideration, and the order passed by the jurisdictional DO is that considering her her health condition till the rationalization process is over, she be retained there. Now, unfortunately, that school gets amalgamated with a high school. The ban is not included there. Now, she files a case here. But there is a post of science teacher vacant there. Some Ruma Devi had retired.
Right, yes.
So, adjust me against that.
And I was teaching in that post also.
Fine. Now, the headmaster acts smart, restrains her even from signing. See, the money was not coming from that school. Money was coming from the earlier school. Earlier school, she was being paid. Now, till March 2018, she gets her salary. February 2018, she gets her salaries. And thereafter, the salary stopped. And no, thereafter, another misfortune. She had to take her wife for treatment, cancer. You don't pay her salaries. She approaches you again. Noticing the issues, you release the salaries till February or March 2019. Right? Now, a general order is issued requiring all the teachers to go back to their respective schools. In the meantime, there are two orders. One is a status quo order by my Lord Justice Sumansham, followed by a final order saying that consider her case, till that time don't act against her. That order, no modification.
To pay.
Pay her salaries as per rules. And then that order was not modified. You did not pass any order. How could you have touched her? Now you institute a departmental procedure saying you are violating our orders, insubordination, unauthorized absence, everything in the world you put there. She comes to this court, assails that. In the meantime, there is a contempt petition because you have not followed the earlier order. Both amalgamated, analogously heard. This court set aside the thing, the order of show cause notice. Now, show cause notice is to determine her misconduct with regard to unauthorized absence. Also, the insubordination. That was set aside. No order passed with regard to the contempt. It was left at that, be that as it may. Now, she submits representation. Finally, and in the meantime, 3 schools were identified. These are the 3 ME schools wherein the petitioner can be accommodated. You don't act on that also.
During the process of contempt.
Contempt, that earlier. That also given up. Now, you finally ask him to join in a particular. He joined in sometime in June or July 2022.
My Lord.
Right? 19 to 22 is the period. You have not drawn up any proceedings. You have not determined whether that period is unauthorized or not. Right? Now you pass an order saying that she is not working, she is not there. Who asked her? Who prevented her? He was ready. Who prevented her? So my conclusion, my direction would be that for that period, already a non-royal certificate and the arrears salary statement is there. Go ahead, release it to her, fix her pay as on the date she was joining, continue with that. Arrears within 6 months, the higher salary, now that fixation within 2 months, right? Higher salaries, she will continue to draw. Arrears, another 4 months. This is the order. We'll pass it.
For this, I'm just placing it. They have to pay me this extra amount also, interest.
What?
Because, Lordship, I have been.
No, don't be too greedy.
I know.
Don't be too greedy.
It was from my.
See, madam, now then if that is.
So, Lordship.
If that is so, if you have made up there, I'll have to answer it.
No,
I'll have to answer it.
Why, Lordship?
Now you tell me, all this period, where is your statement that you were working?
Because I have said I was prevented from working. Yes,
Lordship. Or where is your representation to that effect that you were not being permitted to?
That was, Lordship.
Where is that? The representation doesn't have that.
No, because that one I'm already in the court, before the court.
Okay, that's but where is the order? Where is the observation in the order of the court that you were working, but you were ready, but you were not permitted?
I also stated that.
Where? Just show me that. Just show me that material.
I was not permitted, Lordship.
Show me.
Yes.
I've not passed my orders, so I can always review it.
It's not that. Because I did not want
that interest thing is too dangerous. I'll consider your interest.
No, Lordship, why, Lordship?
Just show me this.
Yes.
Just show me this.
Because it returned unserved. She did not even receive it. I have stated that.
Oh, now show me.
Yes, Lordship.
You were here before the court.
Lordship.
Assailing your show cause notice.
Yes.
Come to the show cause notice now.
That I'm not at all.
I was just recalling the facts.
Lordship.
If I could.
Lordship.
Now I remember. That is the issue I forgot. Yes.
Yes, Lordship.
My Lord Justice made his order.
Para 11, Lordship.
Now come to page 97.
97. Yes.
Now, tell me. Allegation number 2.
Yes, that while you.
And remain unauthorized absence from your duty unilaterally, illegally, willfully till today, and you are not entitled to get your salary as per so-and-so to so-and-so. November 2017 to February 2019. Illegally by suppressing so-and-so, attachment order at so-and-so, willfully, so-and-so, so-and-so, so-and-so. Now show me after this.
This was served on me when the litigations were going on.
You challenge that thereafter.
Yes.
Where is that finding of this court or your submission that you went there, but you were not being permitted?
Lordship, I have stated even in 11, even in earlier petition.
No, this one,
Yes.
2017.
Yes.
The allegation came now. Where is that?
In the order of the court,
Yes.
it was not reflected. It's not reflected.
Where is your submission to that? Forget the directive.
Put it in my petition, Lordship.
No, where is that recorded? Where is that
It
recorded?
might not be recorded, but I have, Lordship, I have put a statement on that, Lordship.
You were not, admittedly, you were not working at that period of time, point of time.
Lordship?
You are not working.
I was, no, Lordship, because I was, the moment I filed this writ petition, I was stopped from signing the register. I have stated, Lordship will kind to page 10, para 11. I have stated that in the earlier petition also. Lordship will come to para 11, page 10. Lordship have come? I've stated here.
Okay.
That's why I have this section.
Kindly pay one more submission. Dated 31st. Requested to join his parent issue, madam. He did not respond in my page 2, madam. Second page, madam. First paragraph.
This order is not under challenge here.
No.
You have not challenged this order. Why?
Lordship, which order?
31-10-2022.
31?
10-20. Oh.
Lordship, there was to the above petition. I'll just go through it, Lordship. I don't know which order is showing.
Here some further order has been passed on 31-10-2022. After the government was moved. This was communicated to her?
No.
Take my.
No.
No, Lordship. 14 September 2022?
31-10.
31-10-2022.
After 22, I don't have anything, Lordship.
No. 31-10-2022.
Yeah, till September, I have challenged the September one. After that, it was never communicated to me.
Because in the September one,
Yes.
it is written that they are sending the matter to the government.
Yes. Yeah. Then in the meantime, Lordship, this Honorable Court perused about this, Lordship. And they have the same stand. No work, no pay.
And Mr. Talukdar, we heard this matter on 10-3-2026, right? Before that, we heard this matter on 2-22-2026. This is a communication given to you on 29-1-2026. Why was this not placed before this court? Why was this withheld from this court on that day? Yes, why was it withheld? We had taken the complete journey, but the basic thing you have not shown us. You have wasted the time of the judicial time. This was available with you from 29/1/2026.
That-
Senior Standing Council, Elementary Education Department. Why was this not placed? Oh, again, Diasnon, that full period.
Same thing, I think.
Diasnon order. Without a departmental proceeding, you are going to hold that unauthorized.
And there's a particular notification also,
I'm
Lordship.
taking it at 2. I want to know why this was withheld from this court on the last date of list.
Lordship, may pass into because
I'll pass the orders. You need not tell me what I have to pass.
I don't.
But why this order was not placed before me
Today,
when the office had given it to you on 29/1/2026? Why was it withheld?
today morning, I print out this from the.
That means it was sent to you
by
on that day.
maybe-
So tell me why this, or this is a backdated one. Then we'll catch the director. We'll ask her to be here. This is not the way you deal with high courts. I'll pass the order at 2:50. And all these orders we are cautioning. But after I'll impose caution. This is not called for. Yeah, free number 2.
Lordship, the thing, what they have, the show cause and everything came in the period when they were direction from this court, Lordship. They already identified.
You got the mind of the court. Now don't give me something which I'll have to change my views.
Obliged.
Free number. Oh. That was a from them. No. Court. Mr. Talra, get that. This is not done. You have instructions, you keep it with you. Whoever it is. Not saying you, saying the councils. Whoever it is, come and let me know what has happened.
In my lordship, directed to
There was an earlier
regulation,
order.
my lord.
Why that was not factored in?
That, I have received the instruction, my lord. But the regulation part, my lord, they have said that after verify screening committee, my lord, they found that they are illegal, irregular. But regarding your lordship query, my lord, that is some fake, my lord. I don't find any.
It bhalke thodi bole. Similar matter. Now, all this thing, I'm finding this language is very common. It's copy paste. That is why the issue was missed out. Yes, Mr. Muya.
My lord, I had been regularized, my lord.
Show me that order.
My lord, may kindly turn to page 43, my lord, Annex 4. My lord.
Where is the
My name, my lord.
page 45?
Page 40, my lord. Page 43, I am referring, my lord. Is the order of regularization, my lord. First,
Where is that? What is this 24/2/2005? That master role regularization.
my lord, on the cabinet meeting held
What is
on.
this cabinet meeting 24/2/2000?
My lord, that records perhaps my lord not.
What is this cabinet meeting 24/2/2005?
My lord, this is a cabinet meeting for the purpose of my lord.
That
those-
Monoharan committee.
Yes,
My
yes,
lord.
my lord, my
Where
lord,
is
it is,
your name in the Monoharan committee?
my lord, it is in this regularization order, my lord, is that serial number 26 and 45 at page 45, my lord. The original, my lord, order also I have annexed, my lord, which is very not legible. So my lord can verify from the original also.
47.
Page number 47 is there, my lord.
So your name was placed before the cabinet.
My lord,
and
my
the-
lord.
Yes. Why? That is why you are not giving us instructions.
My lord.
I'll have to have it by 3 o'clock. What is this? If his name was placed before the cabinet, how can you ignore this order? The cabinet has approved. Everything is done. Who are you to go against the cabinet? If this is not true, tell me it is not true. We will take up the matter with
My lord.
3টা বজাত মাতিম। It's very easy to say illegal, legal. That's why we have asked you why this was not factored in.
That regulation part is vague, my lord, in this.
That why? Who is this? Why is he not required to answer the queries of
I
the
don't know.
court?
Today morning also I applied
You
the,
get it at 3 or we'll have somebody here by 4.
my
This is not done.
Obliged, my lord.
May I please, your lordship? Lordship, Mr.
Yes, Mr. Das.
Yes, Mr.
Miss,
May I please, your
if we require your thing, we'll come to you.
Till date, he has not filed affidavit.
Forget the affidavit. You establish your case, we'll direct. Who are you, Mr. Day? You are appealing for? School. Okay. What is your initial appointment? Leave vacancy.
Yes, Lordship.
It was a provincialized school.
Yes, Lordship.
Thereafter, you were engaged on honorary basis. Show me the power of the governing body to engage you on.
Lordship.
Leave vacancy is no right. That is just a temporary thing.
Lordship.
Once that was over, you were engaged on honorary basis. Show me that you were engaged on honorary basis by a departmental authority.
We come to the petition, Lordship.
Huh?
We come to the writ petition.
I'm with the writ petition.
Yes, Lordship. Now we come to the writ petition. Then here, Annexer 1 is my appointment letter.
Annexer 1 is a leave appointment.
Leave appointment,
Leave.
Lordship. Then resolution was passed. Annexer 3, Lordship. Page
That you show me.
23.
Where is the resolution?
Page 23, Lordship.
20.
23, Lordship.
Hmm.
Resolution. In the resolution, this has been, we included me as an executor also. This is the resolution number 3, Lordship. Executive Committee of Paschim Bonbok Higher Secondary School on 22/11/91.
What happened from 31/5/91? That was the last date till the extension was, leave was permitted to BC Boisha.
Lordship.
He joined back maybe.
Yes, sir, Lordship.
And
He
then
got
you were
retired.
engaged. Huh?
He retired in year 2017, Lordship.
17. So he was there. So there was no post.
But I worked, Lordship. After that also,
Now show me that this page 25 is your.
copy of the letter 13694 for page 26, 20,
So it was already a provincialized school.
Lordship.
If it is a provincialized school, what is the power of the governing body?
Not governing body, but respondents has there's some discretionary power, Lordship, because
Show me that.
I'm coming to the point because
Just show me that, Mr. Das, just show me that.
we are coming to the law, Lordship. We are coming to the rule, Lordship, 2018, Lordship.
Forget
Rule
the
4.
2018 rules. We are in 94 only.
This is
We'll
the
come
new
to 2018.
less,
From
Lordship.
94, you bring yourself to 2018, I'll consider.
Lordship.
94,
Lordship.
there is no rule. It's a honorary school. Your appointment is honorary.
Lordship.
What right does it have you?
So, at that time, there was no such rules at that time.
There is a decision of a division bench of discord
Lordship.
that categorical persons appointed on contractual on honorary basis in a provincialized school shall not have any right for regularization. Tomurodhar Kolita, that is a small order. It refers to an earlier decision of the.
But
What was that?
Jahangir Alam.
Jahangir.
But Jaggu's case, I'm referring to Jaggu's case, Lordship. Jaggu's case, it is
Jaggu, forget. I have a division bench here. I'll follow my division bench. On the point, there is an order of the division bench.
Lordship.
With that existing, it says no right. How can I go beyond that? It's on the point.
Lordship. But
Jaggu cannot have an universal application.
Lordship.
Because your appointment does not have a sanction of the authorities. Intermittently, you were given salaries of a leave vacancies. Leave vacancy again is a settled position, no right accrues.
Lordship.
Mr. Das,
Then
if
remedy,
everything is yes,
any remedy for this case so that 30 years I have
I'll give you the remedy. Don't worry about it. I'll give you the remedy.
Lordship.
You institute departmental, the civil proceedings against the school authorities claiming damages. That's the only way out. And Mr. Das, I've been consistent on this. It's not that I'm passing the order for the first time. I've been passing this order consistently.
Well, Lordship, they may be allowed to file their affidavit.
What affidavit they will file? When you have raised a point only, I'll have to ask them. Now you raise a point on that, I'll ask them.
On that way, there is no such law, Lordship, as per at 94, Lordship. At that time, there was
Forget
no.
94. A division bench judgment, we don't have the concept of prospective overruling.
Lordship.
Division bench judgment will go to the root.
Lordship.
Yes, Mr. Katonier.
Yes, no, this is
You see,
Readable
very
252.
busy looking for something.
readable.
Jahangir Alam.
Yes, my lord. I found.
What is that citation?
Jahangir Alam I could not find, my lord. It's I think 96 or 94, my lord. But Domborodhar is, my lord, readable.
Say that tomorrow. Continue.
Domborodhar, my lord, WA number 252, 2003.
My Lord Justice Gogoi's judgment.
Yes, my lord. Domborodhar.
It's a division bench judgment.
Yes, my lord. It's a readable, my lord.
It says, it does not say much. It only refers to an earlier.
Yes, my lord. And here, my lord, it is applicable in case of LDA also, my lord. That has been said.
Anything.
Because in case of Jahangir Alam, it was
applied it that last date against a grateful employee. Mr. B.B. Devnigi. Yeah, B.B. Dev. Okay, I'll get that thing. We'll pass the order in second half.
Ole Lordship.
I don't know what it is. How are you? You were said to be suffering from high pressure. You're okay now?
Still
So
fluctuating.
why did you come? Health should be more important. We can have these matters if that is the ground, no issue. You can keep it pending for 2 days.
Here it's only already over, right? We'll be going the swing. We have received instruction on 25th month, and we are completing by before Bihu.
Before Bihu.
To try, because people are busy in election duty also.
AG office.
Yes, all offices are engaged. Anyhow, I'll try. We are trying to give before Bihu.
Miss M.M. Kotoki, learned Standing Council, Department of Animal Husbandry and Veterinary, Puramaribade, Assam, submits that the pension proposal of the petitioner has been processed and the same was forwarded to the office of the Accountant General (A&E) Assam for disbursal of the pension and pensionary benefits to the petitioner herein. Also, Mr. C. Borua, learned Standing Council, Office of the Accountant General (A&E) submits that the pension proposal in respect of the pension in favor of the petitioner has been received and the same is under process. Also, He submits that the process involved would be completed by 22/4/2026, and the pension and the requisite orders authorizing the pension involved to the petitioner shall be passed. Also, registry to list this matter again on 27/4/2026, on which date Mr. Borua shall produce before this court the orders issued authorizing the pension and pensionary benefits receivable by the petitioner. Also, registry to list this matter again on 27/4/2026 for further hearing.
Lordship, my name may be recorded. My name may be recorded, Lordship.
Oh, come to the
M. Hussain, Lordship.
Oh, you can claim it. You are there on video. I forgot also it's there on video. You can tell.
Lordship, Lordship, item 27, though affidavit has been filed, Lordship, something has not been brought on record, Lordship. These things are not explained. And we have not received the record as well, Lordship. So I'm
You were supposed to produce the records on last date only.
That's what, Lordship.
Item 27.
27. So matter may kindly be taken up after the Bihu holidays, Lordship.
On the prayer of the Learned Council for the respondents. Oh, Jugalgam, 29.
27.
No, 27, Lordship.
27, huh? 27 day. Learned Council, Miss M. Miss M. Bachaji, Learned Edition, a senior government advocate. The records required to be produced is yet to be received by her. Submits that the records would be used on 23 doesn't include 28/4/2026. Also, no further adjournment shall be granted for the purpose.
Lordship, they have filed their affidavit, Lordship. I would like to file my reply. Lordship.
The parties are at liberty to complete their pleadings before the next date of. Yes, Mr. Botago.
Oblige, Lordship.
Lordship, one item is there, item 22, Lordship, next item. Lordship, in this matter, I have received some instruction, Lordship.
The inquiry report was submitted, but you
Yes,
did not
Lordship.
take any action.
Now, Lordship, after completion of the inquiry, file was forwarded to the Chief Minister of Peace, and he said, Lordship, you calculate the loss that has caused to the state executive, Lordship, and finalize the DP. Lordship,
Yes,
kindly see
returned
the
in the meantime.
No, he has
Then-
not.
kindly see the second page, Lordship. Just the first paragraph, Lordship.
How can this be done now? This is something which you should have done in the inquiry.
No, department has already completed, assessed the amount.
Mr. If a amount is to be recovered, that recovery part, was it an allegation against him?
Yes, Lordship.
Where? Show me in the chokos. Some chokos to some. Sunil Dole. Where is the chokos?
Your Lordship.
This, yes.
Case given us.
2/11/2000, page 32, your Lordship.
So this is the allegation that you had intentionally inflated the amounts. Now, in the inquiry, this assessment should have come in the inquiry.
Assessment that has already been done, Lord.
In the inquiry.
Yes, Lordship.
In the inquiry
Lord,
report, it
yes.
is there.
Exact pecuniary loss calculated from this end. During the inquiry, Lordship. That has been calculated.
In the inquiry report, that is there.
That specific
That I
instruction.
have not been furnished to it, your
That inquiry, because that finding with regard to the
Loss.
recovery
Yes.
has to come in the inquiry.
It is probably there, Lordship. May kindly see the first paragraph, Lordship. The second page, Lordship. It's a letter to the District Commissioner, Lordship, by the PWD Lordship government. The exact pecuniary loss calculated from this end was duly furnished to you or good office for obtaining necessary views, comments, and for further processing of the matter towards closure of the departmental proceeding.
Let them do it.
Date
your
has not been read. So what I'm praying, Lordship, let this matter come after 4 weeks, 6 weeks, Lordship. I assure your Lordship, in the meantime, Lordship, it will be over, Lordship. The departmental proceeding will be decided.
You can't do it, Mr. can't do it.
Let them
No,
do
once-
this, Your
once-
Lordship.
once
But Your
the-
Lordship, my prayer is for reinstatement. If inquiry is completed, why
Your
should I
thing
be
is
put
not
in-
complete. Why keep him hanging?
Lordship, that is what, Your Lordship.
Why keep you post him in Khodia to Dhubri, wherever you want to?
No, otherwise, Lordship, inquiry is already over, report has been
Okay,
submitted, only needs to close the.
Mr. PD Naik, learned counsel for the petitioner, commits that the inquiry report is in the final stages of is under active consideration of the respondent authorities of the disciplinary authority, and only the quantification of the loss caused by the petitioner is to be determined, for which the communication with the district revenue authorities are presently underway. Mr. S. Bhattakur, learned counsel appearing for the petitioner, has submitted that the respondent authority, the learned counsel for the respondents on the last occasion had submitted that the inquiry report has already been submitted by the inquiry officer. However, he submits that the same is yet to be furnished to the petitioner. He submits that during the inquiry proceeding, no attempt was made by the respondent authority, by the department, to have the amount of loss, purported loss caused by the loss alleged against the petitioner quantified. However, he submits that an early disposal of the writ petition is mandated, inasmuch as the petitioner has been, the suspension of the petitioner has been unnecessary, has been prolonged beyond the permissible limits. Also, considering the submission of the learned counsel for the parties, registry to list this matter again on 30/4/2026. Any proceeding now required to be carried out in the matter shall be carried out by the respondent authorities on or before 30/4/2026, and the outcome of the same shall be placed before this court for consideration.
Lordship will furnish me 15 days more, Lordship. 15 days more, May 15, Lordship.
Okay, May
May
15.
15.
Mr. Nothing more now.
Lords,
This is not the way you do it.
deeply of.
Item number 45, 46, 47 may be kindly closed on being withdrawn. 45, 46 and 47.
Mr. R.C. Swekya, learned senior counsel, assisted by Mr. L. Kulita, K. Kulita. J. Kulita. Kind of. Kulita submits that submits on instructions that the petitioners desire not to press this writ petitions any further, and prays that and submits that he be permitted to withdraw the same. Prayer is not objected to by the learned counsel for the respondents. Accordingly, the above noted, the writ petitions being WPC number so and dismissed on withdrawal.
On being closed, on being withdrawn.
On being withdrawn.
Yes. And 46, 47, same.
Same. 45, 46, 47.
Done.
Same. Withdrawn.
Obliged.
Lordship, with regard to item number 27, Lordship has fixed the matter on 28/4, Lordship. There is some difficulty. There are the fixed matters. 34, Lordship.
30.
Obliged.
Difficulty is what?
Other fixed matters are.
Oh,
Obliged.
okay, 34. But that is not a ground.
Obliged.
Matter may be taken after some time.
After some time.
My lord, last support.
I'm not hearing. You have filed your affidavit.
Yes, my lord.
Let them.
My senior instructed me to.
Fine. If you instructed,
Maybe,
rejected.
maybe on Monday, my lord,
I'm
kindly.
rejected. You be here, subtle enough. Yes, madam, what have you got?
Yes, Your Lordship. Lordship, the present writ petition challenges the impugn order of termination of the petitioner who was serving as a contractual assistant engineer under NHM. The impugn order is ex facie arbitrary, Lordship, suffers from non-applications of mind. Facts of the case, Lordship, petitioner was duly appointed and discharging duties, and a show cause notice was issued alleging non-performances. Petitioner submitted a detailed reply explaining the medical conditions, personal legal issues, which is wide, and subsequently, Lordship, official performance reports recorded satisfactory work issued by respondent number 4 and 5. However, Lordship, despite these materials being on record, the respondents proceeded to terminate the petitioners on the very same ground of unsatisfactory performances. But Lordship, authority ignored reply to SOCO's notice, subsequent performance reports. So, Your Lordship, this honorable court in Dr. Vabendra Deka versus State of Assam has held that even contractual terminations cannot be arbitrary and must be based on proper considerations of materials on record, Lordship.
All right.
The present case stands on the even stronger footing as the respondents on records contradict the ground of terminations, Lordship.
Good. Anything more?
No, Lordship.
Miss name?
He does, Lordship.
P. Das, Learned Counsel.
He does, Lordship.
P. Das, Learned Counsel for the petitioner. None has appeared for the respondents. Hearing is included. The date DDI. 304 for delivery of motion.
May I please, Your Lordship?
Hmm.
Lordship, Annexer 6, Lordship. Annexer 5, page 26. It has been from the inspector of school to the director of secondary education for sanction of the post, Lordship. I come to the para, Lordship. Sir, with reference to the,
I've seen it.
it is noted the school has been newly provincialized
read it.
at that time.
Any post-sanctioned?
Lordship,
Post-sanctioned.
it is, I am working on that post, Lordship.
Right.
But now come to the representation time, Lordship. Again,
No, after this page 26, any post was sanctioned.
nothing. And thing is that till since 1991, till date, no selection test has been held. Had it been any interview?
There is no
I could
vacant
have-
post. Why selection should be held?
No, since 2017, that Vinod Chandra post remained vacant. From 2000,
He has been now dismissed from service
he got retired.
or retired.
2017, in that
But
post,
then in 2017, he got retired.
retired, and I am working on that post.
Okay, you came up before this court in 2024. Now, are you within the age limit for recruitment?
No, Lordship, my now age is 57, 3 years left. So representation also, I was thinking that representation will be produce some result,
This is the first time you have come up before this.
Lordship. And thing is that that was also.
You are working as honorary basis now also.
No, now I am getting this cook, this 1,005, and that I am receiving as a midday cook in that school only.
That is
And-
also engagement by the managing committee.
By the school authorities.
Where have you stated that that is?
No, this is the new effects of case incident, Lordship. Now it is different, because when I was in that time, after from January last, I think, one candidate got selected. Since then, till 2025, Lordship, I was in that post. In January 2026, that post has been filled up. Post of Vinod Chandra Bosha. And
Filled up.
yes, filled up. Recently, this is latest information. January 2026. Till that, I was working in that post. Had it been any interview has been proceeded, then I could face the interview.
You were getting your salaries also against that post.
No, I'm coming to the salary point. I received salary for 3 months against the vacant post of Vinod Chandra Bosha, from 1/3/1991 to 31/5 2 months, 1991. Next, I received salary from 2002 to 31/12/2005. 31/5/2002 to 31/12/2005.
In that period, I received the salary of Krishna Reka, grade 4 employee of different school, Gangapukuri Borkuri High School. And that has been, order has been fixed, Annex 6, Lordship. Only these two thing, I received the salary. That from the other candidate, from grade 4 employee from different school.
Okay.
When thing is that, Lordship.
Yes, Mr.
So, admittedly, he was appointed by the school managing committee
And?
after the provincialization of the school, and he was working, initially he was working for 3 months for in a leave vacancy. After that, person concerned joined, and subsequently in the year
No, what is this arrangement you have made at page
26.
27, 29, 28?
It is also against retired vacancy, He
No,
was
that vacancy of some other school.
Other school, my lord.
Why? That means you recognize his necessity in this school.
it was done by the inspector of schools,
Whoever is done it is your officer.
for a particular period,
Be that as it may. Why did he do that?
That, my lord,
That means that his services are indispensable in the school.
now, at present that post has been filled up.
Be that as it may, you have recognized his services. Merely that he is a honorary appointee will not come in, because you have also, along with that, and you see the order, who has been appointed as honorary basic grade 4, he is hereby allowed. That means what?
Allowed,
You are giving a recognition to that appointment.
allowed to draw for a particular period, my lord.
One day also, you have recognized that appointment. So it's not a appointment merely by the school authorities. You have also, departmental authorities have also recognized.
He was working since
So,
1991.
following Jaggo and all, give him the benefit. Regularize his services with retrospective effect.
My lord, right. Presently, there was no post to regularize him, my lord, because that post nowadays, my lord, grade 3 and grade 4 post under the direct recruitment, my lord. So that post has already been filled up.
So these statements here, we will accept that because there is no affidavit by the respondents.
Affidavit, my lord, in fact, we have sent it for vetting, my lord.
This affidavit.
Yes, my lord.
File it by 6th.
My lord.
Yes, Mr. Day, you have anything to say? Mr. Khatonia, NJ Khatonia, learned council, standing council,
Secondary
education department submits that the affidavit in the matter has been prepared and would be filed without fail on or before 6/4/2026. Registry to list this matter again on 9
is holiday.
on 21/4/2026.
Available.
Yes, Mr. Chaudhary. Yes, Mr. Das. What are you waiting for?
Waiting for item 32. Sorry, 35.
The drugs inspector's case.
Yes.
3F regularization. And Mr. Das is 3F
DM.
regularization of
DM,
district malaria officer.
they filed an additional affidavit today. It is not on record, but I can provide you. They have not said that their post has been abolished.
Suppose that cannot be because it is
So
being held.
that was the only point your lordship wanted to know.
And Mr. Chaudhary, what is your basics?
Actually, my lord, earlier, a coordinate bench of this honorable court directed for framing of a scheme and regularization. In the
That was in a
second,
general.
in the second round of litigation, my lord, our prayer for regularization was turned down, against which we have preferred an appeal. However, a direction was issued by the learned single judge that up to the age of retirement, though it is not directly said, we should be retained because we are in service from 2005. That is how the matter stands.
And they have not permitted that.
They have not permitted.
And what happened to the appeal?
Appeal, my lord, I think it is fixed on 8, na? 8.
We'll hear it after the appeal.
My lord, the only thing is,
Only thing that if that order
yes,
was
of
clear
course,
enough,
if
then
the
you could have filed a contempt.
yes.
But that order is not very clear.
Ah.
So it cannot
yes.
be. So
But the purport of the order is, my lord, like something like Upendas.
Upendas, that's what I was thinking when I was reading it, but it was not.
Going by the present trend of the judgments, and lordship, there is a recent judgment, my lord, Bholanath.
Bholanath again can be distinguished. It is specific to that fact.
So
There is a,
here in this case, we have been discriminated also because pursuant to similar order, other departments have regularized.
that is one factor for regularization, which that scheme you all were also eligible. PF, government took a policy one time, but that was turned down. So that is not an issue which I can today consider. That will be
Division bench.
your best relief is division bench. We are not keep this pending, but your only relief way out is the division.
In a sense, I was also thinking in that line. Okay, my
lord. On the heard Mr. K. N. Chaudhary, Senior Counsel, appearing for the petitioner. Mr. Chaudhary submits that with regard to the prayer of the petitioners for regularization of their services, the same being rejected by the coordinate bench of this court, the matter is now pending consideration before the division bench in writ appeal number. Just
give the number.
Writ appeal number so and so. He further submits that the said matter is directed to be listed on 8/4/2026. Accordingly, registry to list this matter again on 27/4/2026. Mr. Das, not sure whether we can.
Your lordship has heard the matter.
No. We'll have to consider it first. Mr. Bora is here.
Can I take one liberty, Miller? There is one item number 52. It may come after the vacation, Miller.
There is a mediation report there.
Yes. All that lordship can, I think it's lordship can wait till then. I think your mediation to fail only. What?
No, 52 to something.
Mediation to fail only.
Mr. Bora, Mr. Das, you can just get first, Bora.
No?
Not settled. Not settled.
Therefore, my lord, it will come up for after the vacations.
On the prayer of Mr. K. N. Chaudhary, Learned Counsel for the petition, submits that Senior Counsel for the petitioners. The mediator has submitted a report, a negative report of the matter not being concluded successfully for the meeting before her post-op. Accordingly, he submits that the matter be taken up for admissions after the ensuing Bihu vacation. Accepted. Registry to list this matter immediately after the reopening. After reopening, on reopening of the court after the ensuing Bihu vacations.
Let's fix the date, lordship. Lordship is fixing a date.
Yeah, withdraw, Bora. Withdraw, Bora. Mr. Das, if Mr. Bora is here.
On his way.
When Mr. Bora is here, just interrupt me. I'll by the time I'll pass some. There's an order to be passed. I'm passing it. You just interrupt me in between. No problem. Yes.
I will kindly peruse the order dated 31 on 2026. Your lordship order dated.
That is reflected.
My lord. That tag mark I will.
X to Z.
Okay. Same thing.
My lord.
No, this is different.
Yes.
This is different. This is 25/1/2024.
26.
This is 29/1/2026.
But instruction is same, my lord. Maybe date. I have to check it, my lord. Letter, my lord, X.
Not the same, Mr. It is not the same, because here you have two further orders. Where is that Dyson order gone now? Huh. 4/4/24. 4/4/24 order has been added here. Then that is the addition, 4/4/24. That means the period regularized by granting of extraordinary leave, so and so only provided no other financial benefit. Where is this order? This is an order of 4/4. Could not have come on 25/1.
Can I say, my
It-
in the record, my lord, I have not gone through this order, my lord, but I saw that.
That
this-
order is not there.
My lord,
Okay, forget it.
my lord.
But Ms. S.P. Hussain, learned counsel for the petition. Also heard Mr. B. Talukdar, learned standing counsel, elementary education
Elementary
department. Ms. D. Musahari, learned standing counsel, secondary education. Also, Mr. At the outset, it is to be noted that Mr. B. Talukdar, learned standing counsel, elementary education department, in continuation of the instructions furnished by him furnished before this court on 31/2026, has furnished another set of instructions today, which is dated, issued by the Director, Elementary Education Assam, dated 29/1/2026. Also, this court has taken the said instructions on record, and the orders enclosed thereto would be considered along while considering the considering the orders under challenge in the present petition, inasmuch as the said orders are also have been so issued by the departmental authorities in continuation of the orders already under challenge in the present petition. Also, the petitioner, by way of instituting the present petition, has presented a challenge to an order dated 14/9/2022, issued by the Director of Elementary Education Assam, wherein, after concluding that the petitioner was not entitled to, concluding, basing on a report submitted by the jurisdictional block elementary education officer, it was concluded that the petitioner was not entitled to his area salaries with effect from 1/3/2019 to 8/6/2022 on account of being unauthorized absence by applying the principle of no work, no pay, had forwarded the matter to the government for further consideration or for necessary instruction. So, as projected in the petition, the petitioner was initially appointed as a science teacher in Taki High Super ME School, Nagaon, with effect from 29/1993. Also, the petitioner thereafter submitted an application before the jurisdictional district elementary education officer for his transfer to Town Panigaon High School against a vacant post of Town Panigaon ME School against a vacant post of science teacher available therein. Also, the petition, in lieu of being transferred to the said school, came to be attached thereto, and the petitioner accordingly joined his attached post. Also, as the petitioner was continuing in his attachment with at Town Panigaon ME School, such attachment came to be cancelled by issuance of an order dated 2/11/2009. Also, subpara. Being aggrieved, the petitioner has had approached this court instituting a writ petition being WPC number 5244/2009. Also, this court wide order dated 27/11/2009 proceeded to for 27/11/2009, 27/11/99 upon 2009, no? Upon considering the issues arising in the said writ petition, proceeded to 2009 day, proceeded to dispose of the same by directing the District Elementary Education Officer, Nagaon, to consider the petitioner's representation and pass appropriate orders therein. It was further observed that the respondent authority, while shall also take into consideration the medical condition of the petitioner, and the decision as arrived at in the matter shall be communicated to the petitioner. Also, in compliance with the directions passed by this court wide the order dated 27/11/2009, the jurisdictional district elementary education officer wide order dated 8/1/2010, taking into account the medical condition of the petitioner, proceeded to stay the operation of the order dated 7/11/2009, by which his attachment with Town Panigaon ME School came to be cancelled. Also, the petitioner thereafter submitted representations on 9/1/2010, praying for his permanent absorption at Town Panigaon ME School. The same not being considered, the petitioner approached this court again by way of instituting a writ petition being WPC number 330/2014. A coordinate bench of this court wide order dated 1/7/2014, upon appreciating the issues arising therein, proceeded to dispose of the said petition by directing the jurisdictional deputy commissioner to consider and pass appropriate orders with regard to the consider the representation of the petition submitted by the petitioner and to pass appropriate orders therein. It was further provided that till the completion of the aforesaid exercise, the service of the petitioner as science teacher in Town Panigaon ME School shall continue also. Was thus the jurisdiction district elementary education officer proceeded to issue an order dated 25/8/2014, by which the petitioner, in compliance of the directions passed by this court in WPC number 3330/2014, was permitted to continue in Town Panigaon ME School till completion of the rationalization process. Also, a development thereafter had taken place in the matter, which has a bearing in the which has a bearing with regard to the grievance raised by the petitioner in the present proceedings. Also, the Town Panigaon ME School came to be amalgamated with Dimoruguri High School under the Shiksha Mitra scheme. Also, wide issuance of an order dated 24/2/2017. On such amalgamation in the list of teachers now figuring in the amalgamated school, the name of the petition was not included. Also, it is at this stage that the respondent authorities proceeded to issue an order dated 21/10/2010 by which all attachment orders in respect of teachers of elementary school under Nagaon district came to be cancelled, and the concerned teachers who were under orders of attachment in a school other than their parent school, were directed to rejoin their parent schools with intimation to the jurisdictional DEO. DEO to Bishop Koidivi, but DEO to Maidi. Also, the petitioner has projected in the petition that upon the amalgamation of the town Panigao ME school with Imoruguri High School, he was allowed to work against the vacant post of science teacher available in the said school, and accordingly, the petitioner continued to discharge his duties in such capacity, with his pay being released from his parent school, that is Aki Thai Super ME School. Also, accordingly, the petitioner submitted a representation on 8/11/2017 before the President, SMDC, Imoroguri High School, praying for submission of a proposal before the departmental authorities for absorbing the petitioner against the post of science teacher available in Imoroguri High School. Also, the said prayer not having been taken to its the said prayer of the petitioner not having been considered in the considered by the departmental authorities, the petitioner approached this court by way of instituting a writ petition being WPC number 7191/2007. A coordinate bench of this court, while ordered it 27/11/2017, while issuing notice in the matter, considering the issues arising therein, was pleased to direct that status quo as on today with regard to the service of the petitioner be maintained. Also, the petitioner projects that after the institution of WPC number 719/2017 and the order of status quo as passed by the coordinate bench of this court, widely order dated 27/11/2017, he was restrained by the headmaster of Guri School, High School, Imoruguri High School, from taking classes in this school and also signing on the attendance register. Also, this court thereafter took up WPC number 7191/2017 for a final consideration, and while order dated 20/12/2017, noticing the grievances of the petitioner, proceeded to direct the Director Elementary Education to consider the grievance of the petitioner. Deputy Commissioner, Jurisdictional Deputy Commissioner, to consider the grievance of the petitioner and pass appropriate orders of posting by taking note of the difficulties faced by This court, according to the bench, further provided that the jurisdictional deputy commissioner shall also ensure that the petitioner is paid his salaries and allowances as per rules. Also, the directions passed by the upon passing of the said directions by the order dated 27/12/2017, the petitioner submitted a representation on 26 a second order to 2012 over there, disposed of on 2012. Representation on 26/12/2007, wherein by referring to the problems faced by him, and also the by referring to the medical ailments suffered by him, prayed before the jurisdictional deputy commissioner to consider his case or appoint permanent absorption against the vacant post of science teacher, which had arisen in Dimuruguri High School on retirement of the incumbent therein. A similar prayer is also seen to have been made before the jurisdictional district elementary education officer. Also, the other facts would be of the further developments taking place in the matter would be of no importance. But what is to be considered is that a report was submitted by the jurisdictional district elementary education officer on 19/12/2018 to the jurisdictional deputy commissioner in connection with the contempt case being contempt case number 192/2018 by the petitioner hearing. And therein it was brought on record that the petitioner was not found to be serving in the school with effect from 14/11/2017. Also, it is to be noted that the respondent authorities at this stage proceeded to carry out an exercise for identifying vacant sanctioned posts of science teachers available in the upper primary schools in the district of Nagaon for the purpose of posting of the petitioner. And in this connection, had identified 3 such vacant posts which could be utilized for the accommodation of the petitioner. Also, this court-wide order dated 20/12/2017 having directed the deputy commissioner to pass the jurisdictional deputy commissioner to pass orders upon the representation of the petitioner. The jurisdictional deputy commissioner had instituted an interlocutory application praying for a modification of the said direction, in as much as he had projected that he had no jurisdiction with regard to the grievances for redressal of the grievances raised by the petition was to be so redressed by the Director of Secondary Education. Accordingly, this court-wide order, according to the bench of this court-wide order dated 9/9/2019, proceeded to dispose of the said interlocutory application being IA bracketed C number 1575/2019, now requiring the respondent number 3 therein, that is the Director of Secondary Education, to take appropriate appropriate steps for complying with the directions passed by the coordinate bench of this court widely order dated 2012-2017. Also, they said developments having taken place, the petitioner was issued with a show cause notice dated 11/5/2020, instituting a departmental proceeding against her. Also, on the count that he had remained unauthorizedly absent from his duties unilaterally, illegally, willfully, till the date of issuance of the said show cause notice. Also, at this stage, it is to be noted that the salaries of the petitioner, which were being released till February 2019, was stopped with effect from March 2019. The petitioner, being aggrieved with the issuance of the show cause notice dated 11/5/2020, assailed the same by instituting a writ petition being WPC number 2650/2020. Also, during the pendency of the said writ petition, the departmental authorities had directed the petitioner to appear before the constituted medical board for a clarification with regard to the projection made by the petitioner that he was suffering from various ailments which had prevented him to revert back to his parent school. The medical board, on examining the petition, while its report dated 1/3/2021, proceeded to hold that the petitioner was in fact suffering from the ailments projected by him. However, in the said report, there was no. However, in the said report, it was not dealt with as to whether the petitioner could have continued to discharge his duties in his parents' school. Also, the coordinate bench of this court proceeded to hear WPC number 2650/2020 and contempt case number 192/2018 analogously, and disposed of the same wide judgment and order dated 26/8/2020. The coordinate bench, after considering all the relevant materials brought on record, proceeded to interfere with the impugned show cause notice, with the show cause notice dated 11/5/2020. So, however, a liberty was granted to the respondent authorities to start a de novo proceeding against the petitioner in accordance with law, if so advised. However, what is relevant to be noted is that the coordinate bench further directed that the issue of posting of the petitioner in an appropriate school concerning his health condition, and also the issue of release of salaries, both current and arrear, be looked into by the respondent authorities, more particularly the Commissioner and Secretary to the Government of Assam Education Elementary Department. Also, in pursuance to the passing of the said order, the Secretary to the Government of Assam Elementary Education Department, wide order dated 11/5/2022, proceeded to direct the Director of Elementary Education to take necessary steps for posting of the petitioner in an appropriate school, considering his health condition, and also address the issue of release of current and arrear salaries to the petitioner. Also, in terms of the said directions passed both by the coordinate bench of this court and the Secretary to the Government of Assam Elementary Education Department, wide order dated 11/5/2022, the district level departmental authorities proceeded to submit area salary statement of the petitioner along with a non-royal certificate pertaining to non-royal of such salary by the petitioner. Also, it is under that circumstances, it is under the above circumstances that the Director Elementary Education wide order dated 14/9/2022 proceeded to issue the impugned order. It is under that circumstances that the Director of Elementary Education proceeded to issue the order dated 14/9/2022 and therein literally foreclosing the claim of the petitioner for withdrawal of salaries for the period with effect from 1/3/2019 to 8/6/2022. Salary order to Ragot. Salary statement to Agot. Salary statement potale. Also, the petitioner was wide order dated 23/5/2022. In terms of 11/5 কথা কৈছো নহয় তাৰ পিছত in pursuance to the order dated 11/5/2022, the jurisdictional District Elementary Education Officer proceeded to post the petitioner at Molkundra Das Vidyapit ME School wide and order dated -. So, তাৰপিছত area salary teller. Also, being aggrieved, the petitioner has instituted the present writ petition. As noticed herein above, from the foreclosing the claim of the petitioner. However, no final directions came to be passed by the said impugned order, and the matter was placed before the government for further instructions. Also, from the instructions furnished by Mr. B. Talukdar, Learned Counsel, it is seen that on receipt of further instructions from the government, the Director of Elementary Education Assam, by order dated 31/10/2022, had proceeded to hold that the period of absence of the petitioner with effect from 1/3/2019 to 8/6/2020 be deemed as unauthorized absence, and by application of the principle of no work, no pay, ', the petitioner was held to be not entitled to any salary for the said period. Also, the instructions further brought on record an order dated 4/4/2024 by which Mohendra Das, Mohendra Das, by which the period of unauthorized absence of the petitioner with effect from 1/3/2019 to 8/6/2020 was regularized by grant of extraordinary leave for the purpose of pensionary benefits only, and it was stipulated that the petitioner would not be entitled any other financial benefits for the gap period. Also, all the facts have come. As Mr. B. Talukdar has furnished further instructions in the matter, the same would now be mandated to be considered by this. Accordingly, the delivery of order is deferred. Kali Thursday, Friday bondhoni. Monday, 6-4. I'll pass the order.
Sure, Ash.
Yes, Mr. Why are you waiting?
In that case, Lordship, we have filed additional affidavit.
Today, that's
So let the matter be fixed for final disposal, maybe on 6th or 7th, whatever date is convenient.
Yes.
Tuesday next, maybe subject to Lordship's convenience.
No, it is convenience of two stalwarts.
That is just before the vacation. That is why I'm.
Hearing. Additional affidavit has not come on.
Yeah, it has been filed this morning.
What is your stand there?
They are trying to indicate that these posts are required. We have.
Mr. Soikia, what has happened? You were not here on the other day. What the development that took place is that these people were asked to go. That PF we don't want anymore. So there are orders of this court which had mandated that they should directly or indirectly, they were to be continued. So the impression this court had got was that these posts not being required by the government, maybe because the submission made was, we don't have incidents of malaria now, which is also difficult to somehow swallow because the National Vector Development Scheme is still continuing. And it is there in full, but be that as it may. Then this post should have been abolished one way. Or you could have kept that post there without requiring anyone to manage. But the material subsequently that have come on record, it reveals that the next in the hierarchy person, he is now allowed to look after the post on officiating.
No, he is giving in charge because we have to have some person, but the scope of work is very limited. So no additional work is given to him.
Then why is an assistant malaria officer required? If the malaria is not there, then why an assistant malaria officer is required and why is he required to hold the charge of a higher post?
Because we do not have that kind of requirement at this stage. So these additional persons are not required.
Okay. You are now manning that post with
the existing stuff.
Existing stuff. That means that post of I want that answer. Post of DMO. District Medical
Officer feels that we should abolish that post.
No,
if it is not required.
You have not abolished the establishment. Are you manning that post?
So these two persons.
Mr. Soikia, something for you. Are you manning that post because the district malaria officer is the DDU? So somebody should be there at least to draw the funds. Is it for that purpose?
No, then that is very deep. Lordship is going very deep now.
I only wonder if that is the purpose, then the other things will fall into place. That means you don't require for works, but you require for DDU.
For that.
So you require for DDU.
We have no personal enmity that these people should go. That is number one. Number two,
sure.
Whether we have recruited fresh person there. No.
Mr. Soikia, we want to be sure that what you said is correct. And these people, we don't want these hands.
Lordship.
And we have put a person in DDO only as a DDO so that he can draw the bills.
Lordship, I fully appreciate Lordship's query and Lordship where Lordship is looking into. If that be the case, then let this matter come up in the first week of May. I will call the whole office staff, I mean the persons who are at the helm of affairs, to know the complete nitty-gritties of the administration there. Then only I'll be able to address it. Otherwise, the instruction is very clear that they are no more required. We had not have.
Mr. Soikia, materials have come on record that you are planning that
one thing is very clear, Lordship. The employees cannot say what the employers should take.
No, I'm not on that. I'm not on that. I'm not on that. I'm not even on that. See, grievance has been raised. I'll have to answer that.
Lordship, definitely.
That's why I was asking Mr. Bora that if you are doing an in-charge arrangement, then that in-charge arrangement is for the works related to the post in the field or works related to that post in the office.
Exactly.
There is the difference.
That is why I have to look into the roles and responsibilities of each of the persons manning that office.
Because he is a DDU. If you have not abolished that establishment, you will have staff. So somebody will have to draw from that post the salaries. So you put a in-charge principal or a in charge normal schools.
One thing is very clear. What post blood?
District manager.
District manager. DDO is a additional responsibility for disbursement of salary and other things. But the main role is to counter the effect of malaria.
So, okay, I'm making this query in
Yes.
your favor.
Yes, Lord.
Because if it is only for the purpose
Exactly.
of DDO, then that means you are not
Somebody will have to take the role of DDO.
You get that instruction.
Yes.
We'll see.
Then first week of May, Lordship.
And
That's
then what do you say about Bholanath, Jaggo, then the series of matters that have now come from the Supreme Court?
This is a different issue, Lordship. Here it is temporary and contractual employees. Ours is not temporary and contractual employees. Ours is their statutory employees under 3F regulation.
Better placed. They are against the post.
Better placed.
Because
But
see, here
they are governed by regulation 3F, which very clearly says that they do not have any right beyond 4 months until it is extended. So
Now-
I'll distinguish. This is
Now-
a very clear case of distinction.
Mr. That's what I want. That's what I want to. These are queries in my mind. That's why I'm just putting it out to you.
Lordship.
That is one aspect. Second aspect is that there was a recruitment exercise for the post of DMO, which was put to challenge before this court. This court had set aside the recruitment process. Now, have you taken a decision after that? Have you taken a decision just to add up to the things? Have you taken a decision? Okay, this has been set aside. We are not going further because we don't want this. Now the incidence of malaria has come down, so we will not immediately go for a recruitment. If you have taken that, bring that also on record.
Lordship. Will not go wrong. I will do that.
So we have a connection. Then we take a call whether Jaggo, Dharam Singh, Bholanath should be there or should come heavily down.
In fact, all these judgments, that Bholanath and all 3 judgments, it is directly in conflict with Uma Devi. Directly. That's a full bench judgment. At one point of time, Supreme Court will have to give a counter because the judicial discipline has been violated. If we go by the official liquidators, in fact, immediately for the first week after vacation, I am not here. From 25 onwards, I am there. But lot of other cases were fixed.
We will have it on 5th.
5th of.
But no further adjournment.
No.
We are closing the matter.
I wanted it on 8th only, but Lordship wanted some. Then Lordship, all the queries I won't be able to, because all my officers are with election part. That is why otherwise with the affidavit, whatever is there, and Lordship will
No, I
not
want
raise
this-
any additional questions.
This addition.
That additional questions on factual aspects, I cannot disturb my officers right at this moment.
fine. We got
They
it.
are all on election duties.
We give you the
What's his query was whether the post has been abolished.
no.
This was.
The role and
See,
responsibility.
See, I want to be very sure that because
That's a
after
different
the
thing.
passing of this order, they should not go back and again recruit people under 3F or 4D or something against that post. That should be, if they say it's not there for all the
In
time.
fact, we have waited.
Until
It's
a
not
situation
said by the
arises
report.
wherein the malaria incidence increase.
Not only malaria, there were Victor and other official assignments are also there. So, only your lordship's query was whether the post has been abolished. They say post has not
Not
been
been
abolished. It is somebody has taken in charge of the post.
Let
That
the
the charge has
state,
been
let
also
the
given.
state, Mr. Das, let
So
the
he is
state come in.
Bring to 8th.
Let the state
How
come
can
in.
I agree to
Let the
that?
state, let the Advocate General have his instructions, complete instructions, complete instructions, because Mr. Das, if I get that instruction that these posts are being still manned for the works in the field, that's the end of the matter. I'm not going to hear the Advocate General any further. I'll pass the order that you should be reinstated back. Regularization, we will see. But if it is shown that no, a conscious decision is there, even after the setting aside of this election process, to not go for this because of X, Y, Z, and the post is being manned only for the purpose of DDO works, then maybe we'll have to keep our hands back.
My worry part is this only, my lord, these persons, they were, my lord, not getting
So I will
salary from.
place, sorry, I'm
from
sorry.
Mr.
April-
Das,
That's
rest
the
assured,
of the court.
rest assured, if I have to come with you,
Family.
if I come with you, I'll see to that all these things are taken care of. Don't worry about.
Orders of the court, man, they're not getting.
I am with you. If I come with you, I'll take care that this is done. They will have to subject to appeal. They will have to comply.
The whole
you leave it to
family.
me. Lekha.
Despite
Heard the
orders of the
learned
court.
counsel for the learned, heard Mr. B.D. Das, learned senior counsel appearing for the petition. Also heard Mr. D. Saikya, learned advocate general Assam, for the appearing for the respondents. Also, Mr. Bora, DP Bora, learned counsel assisting the advocate general submits that he be given time till 5/5/2026 to place on record materials with regard to the queries raised by this court pertaining to the functioning of the post of district malaria officer as on date. Also, it is to be noted that materials have come on record that the post after the petitioners were released therefrom are being manned on in-charge basis by the officers officers holding post subordinate to the post of district malaria officer. Also, prayer accepted, registry to list this matter again on 5/5/2026. It is provided that no further adjournment shall be granted in the matter, and on the next date of listing, the matter shall be taken up for final consideration, both on the issue of the release of the petitioners from their respective services, as well as with regard to the prayer of the petitioners for regularization of their services.
The additional affidavit filed today should be on record.
That will come.
Hopefully, when.
For further hearing.
Yes,
Done.
Deeply obliged.
that interim order is there.
Interim order passed earlier to continue till the next date only. Yes.
Regarding my lord, I've talked with the department, my lord, regarding the regularization, my lord, that page 47, my lord. That was not regularized, that is proposed to be regularized, my lord.
No orders were passed. No orders regularizing was passed.
No, my lord, subsequently, our affidavit in page 101, my lord, we have stated that the initial illegal teacher writ petition was pending, my lord. My lord, page 101, my lord. Paragraph 6. That in the meanwhile, the issue of illegal irregular appointment of teacher across the state under consideration of this honorable court in various state proceedings. This honorable court in such proceeding directed education department to take a call in the regularization irregular illegal teacher accordingly in terms of order dated 2/3/2000 passed by the honorable court in WBC 104/2004, my lord. That was 2004, and the proposal was on 2005. Already, my lord,
No, this regularization is 2006.
2006 proposed to be regularized, my lord.
Where?
Kindly
Yeah,
say,
it's regularized. Page 43.
Hereby regularized, my lord.
And that is stated to be in terms of the cabinet decision, 2005, 24/2/2005.
but my lord, here, my lord, in for page 47, my lord.
Where have you said that this order was never, it was only proposed, not final in your affidavit? Illegal, we understand.
Right.
Illegal is illegal, no problem. We understand. But the petitioner has brought on record a fact that, see, my services, 125 teachers, my services were regularized. What do you have to say on that?
And subsequently, some of the petitioner are accommodated, my lord, except Out of 14 petitioner, my lord, 9 petitioner were accommodated,
Do you get what I'm asking you?
my lord.
Then kindly answer that. What do you say about page 40? And that is the exact query I think I made it. My English is bad. Maybe I've not been able to communicate. That is exactly what I wanted.
But my lord,
He be granted time till 1/4/26 to receive instruction as to why the earlier regularization of the petitioners was not factored in while passing the impugned speaking order dated 23/20. Note in the earlier round of litigation, so and so, along with others, wide order, had noticed the regularization so and so, and thereafter had passed directions with regard to the grievance expressed by the petitioners that their services were not being, salaries were not being released even after they were regularized. Now tell me.
that
And you
order,
want the orders? We'll give you the orders. Come to page 69. Para 13. You are finding it difficult with.
the- it is my lord, Anjuara Begum, my lord, please. Anjumara
Isn't
Khatun,
that 125 list?
my lord,
Huh?
Anjumara Khatun, my lord.
You tell me this is what Mr. Mia is projecting is totally perverse, misleading this code. I'll get hold of Mr. But without telling me that, how should I disbelieve Mr. Bhuya? And you pass an order thereafter. 24, 7, 20, 28, 15. That is with regard to Anjana Khatu. Yes, yes, tell me, why, what is this position of this 125 list? You can't. Mr. We don't have time. Whether you can reply or you
At
can't.
this state, I can find.
Huh? At this stage, you cannot. When can you? You said you had a discussion with your officer.
They have said, stated about that, my lord, they proposed, my lord.
Propose.
My lord.
Get me the document which shows that it is proposed. Get it in fax. Who gave you that instruction?
And
That officer may be available. Ask him to come online. We will talk. Now, immediately.
or day after tomorrow, my lord. Or tomorrow, my lord.
Today. Whatever time it's convenient to you. I'm here.
I will do.
I just want to know what happened to page 43.
My lord.
Whether his name was included therein after cabinet approval. If that be so, that's the end of the matter. But you tell me now, this is all bogus. Nothing happened in this. So there is no cabinet approval. Bring the materials on record. I'll get against them.
As last item, my lord, I will.
Before I rise, come here.
My lord.
Or I'll pass an order tomorrow, 10:30, your officer will.
My lord.
Mr. Bhuyan, we'll
My
have to wait. Can't help it.
My lord.
Wait, some other.
Last order may kindly be seen.
Have you released?
My lord.
Money given?
Yes, my lord. Not all, my lord. Not all.
It's a day you have put it from this side to that side.
No, my lord, actually, I'm not with this case.
Not so far as PF, leave salary and group insurance amounting in total to be 5,31,185. That has been, my lord, released.
But that's
third
When
page,
did the father of the girl die?
Died on 26/3/25.
26/3/25.
Yes.
the gratuity amount, my lord, that has been, will also be released. I have taken instruction, my lord, due to non-vacation of the,
You don't pay them and you also don't allow them, pay them, they will leave it within 1 month.
no, they have left it,
Left it.
left, my lord.
When are you paying them?
Not today, maybe by tomorrow it will be done.
Tomorrow.
And
The amounts have been given, only that,
yes,
15
and
lakhs.
so one more amount, my lord, that medical reimbursement amount, some amount is pending there.
where is your prayer to that effect?
No, no,
Then?
no, all benefits. my lord.
Medical reimbursement is not a pensionary benefit, Mr. Singha.
Not pensionary, I know,
Then?
my lord.
Then?
But that has been pending before them, my lord.
You
I
file
have to come
appropriate
again otherwise, my lord.
You file appropriate application before them, we will provide for that. But I can't pass a direction
My lord,
because
we
there is
have
no
filed.
material here.
No, of course, my lord.
There is no material, Mr. Singha.
Yeah,
What
I
is your
imagine,
amount?
but-
What is that thing? We
but
don't know.
The pendency, but pending of those deceased amount money. This is also amount pending,
Mr. Sinha, you have only prayed for
pension
your
and pensionary
pensionary
benefits.
benefits. So if pension and pensionary benefits, we have materials, we have taken up the matter, now they have cleared it. With regard to your medical reimbursement, we even don't know what it is. If there is something, you approach them with an application, they'll
My
consider.
lord.
No, they will not
I'll-
consider, my lord. I know.
Order to that effect.
Yes, my lord, yes. That
That
will,
you file
yes,
a
that will
application
consider.
within
my lord.
15 days.
Yes, my lord, yes, my lord, yes.
The petitioner through her natural guardian will file an
Yes,
application
ma'am. Yes,
within
ma'am.
15 days.
Yes, my lord.
My lord, another thing I will
That
just
much
point
is
out, my
enough,
lord,
my
11-2 order.
Hmm.
My lord, there was a direction by the court that the petitioner will file an affidavit, my lord, stating that the amount which has been deposited shall be accounted for the maintenance of the minor daughter.
Yes, my lord. I have.
That statement has not been made in the
I think it
affidavit.
is the record, my lord.
Because, my lord, it's a special case where this minor will get, my lord, until she attains the age of majority. My lord, paragraph 4 is the statement perhaps which my learned friend would like to point out. But it nowhere gives that declaration that,
You have started releasing the pensionary amount?
yes, with effect from, my lord,
Like-
27/3/25.
Lekha. Heard Mr. B. Sinha, learned counsel for the petitioner. Also heard Mr. H. Gupta, learned CGC appearing for the railway respondents. In terms of the directions passed by this court on the earlier dates of listing, Mr. Gupta has placed on record the instructions dated 3/3/2026 received by him from the railway respondents. On a perusal of the said instructions, it is revealed that the pensionary benefits of the petitioner or receivable by the petitioner on account of the services rendered by her deceased father has been released accepting an amount of rupees 15,65,500 being the amount due under the head death come retirement gratuity. Death come retirement. Death dash come dash retirement gratuity loan. Bracketed BCRG. Also, further, the petitioner has also been authorized a pension, family pension at the rate of rupees 25,000, 25,250 per month, along with other admissible allowances, with effect from 27/3/2025, and it is submitted that the arrears thereof has already been released.
No, that I have to take confirmation exactly.
Also, Mr. And this 5 lakh has been released? No.
5 lakh has been released, man. That is page number 3, my lord, of that
You are
instruction.
receiving your pension?
5 lakhs, I do not know now that.
Pension you are
But
getting?
yes, pension is getting.
Pension.
Yes.
They do not know, my lord. They are maintaining the child. They do not know, my lord.
Oh, well,
Their account, they are maintaining. They should know it, my lord.
Mister, you are standing not as a council here, you
My
are
lord.
standing as a representative of the railways.
My lord.
So please be very
My lord.
choosy
Lord,
in your
we
words.
are also
You be choosy on your
my lord,
words.
my lord.
I'll not tell you what to do. You be there. I'll tell you.
Reference.
Lekha, kila. Don't make any vague statements like this.
No.
Huh?
একটু দিয়ে আসছে তো আপনার কোনো
As areas have also been released as contended by Mr. B. Sinha, learned counsel for the petition. So, while the respondents are directed to continue to release to the petitioner the monthly family pension in her account, and also to release the DCRG amount, the general manager, or who is the personnel head? Who is the person? General manager P.
Yes.
Huh?
General manager
Personal, general manager personnel shall on a monthly, shall every month depute a welfare officer of the railways. I think it's called a welfare officer.
My lord.
It's called a welfare officer.
Welfare officer.
To the residence of the petitioner and collect information with regard to the welfare of the petitioner and as to whether the amounts received in the account of the petitioner is being utilized for the welfare of the petitioner by her mother, who is her natural guardian and who is representing her in the matter. Also, the said reports be collected from the current month and be placed before this court on the next date of listening. Also, while collecting the report, the welfare officer shall invariably interact with the petitioner and receive inputs from her. In the event the petitioner is found to be in any difficulty, the railway authorities shall act immediately in the matter and take all requisite measure for protecting the interest of the petitioner herein. A amalgamated report till the next date of collected till the next date of listing be placed before this court through Mr. H. Gupta, learned CGC, appearing for the respondents. Also, raised the amounts as deposited in the account of the petitioner be permitted to be utilized for her welfare as and when be permitted to be withdrawn for utilization in respect of the welfare of the petitioner to be utilized for meeting the needs and other meeting the needs of the petitioner. Needs of the petitioner. Also, registry to list this matter again. On 3/8/2026. We are keeping it, we are monitoring it.
My lord. Give one copy also, the instructions.
And
We are
my lord-
monitoring it.
Okay, my lord, that medical reimbursement, what the.
That will come, will come.
Is
You
that
submit
submitted?
an application, file an additional
File-
affidavit, we'll see.
But that may be observed, I may be allowed to submit, my lord.
You submit.
My lord, my lord, where your lordship order will, my lord, the act, my lord, otherwise
What
I'll
is the
submit
rush?
again.
What is the rush? We are here, don't worry. Let
Well-
us see your conduct for 3 months.
Okay.
Let us see your conduct for 3 months. You are the mother.
Yes, my
But
lord, yes.
unfortunate that you have to be brought in such a situation.
Yes, my lord.
But our concern is the
Daughter, my
daughter.
lord. Minor daughter only, my lord. Yes, my lord. Because-
You are a natural guardian,
Yes, my lord.
but a cloud was created. We just want to remove
No,
that.
created by the railways, my lord.
Whoever it is.
Yes, my lord.
Let
Because,
the railways welfare officer go and if it is a lady who you are sending, it's better.
My lord.
Don't send a male. Hey, Maury. A female welfare officer. Girl child.
Girl child.
Girls, girls.
Female welfare officer. Let us monitor. Thereafter, we find that you are fine, we will leave you. You do whatever you want with your daughter. Or we'll get your daughter here and interact with her.
Till the death of the father, my lord, he was with the grandmother.
No, 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 no. That is.
She is a divorced.
No, no,
She is
I don't-
divorced.
Uh,
She is divorced.
just move out of
Yes.
this court.
I don't know how she can
Just
say.
move out of this court. Then you can have a big
Because-
discussion, Mr. There.
Yes.
Both of you can go and out have a. The case is over. Case is over as far as.
the
If you have to have further discussion, kindly go out, or there is a
Yes.
canteen, good
My lord.
canteen.
I don't know
Go there.
why railways are doing
Oh.
like this, madam.
Young boy, Mr. Sinha, you are a veteran now. Young boy, he is agitated. Let it be. Let it be. Called.
I'm only concerned about the daughter.
You be concerned. Now you show that concern through your welfare officer.
Oblige, man. Oblige.
Obviously.
We'll see then.
Oblige.
And if something is there, Mr. Further hearing going to be there. I'm monitoring it. Let us see. Yes, sir.
Yes, Lordship directed to produce the instruction. I have received the instruction, my lord. Lordship may allow
Direct you to produce any instruction.
last.
I directed you to get it in writing. Stand.
Stand I received, my lord. So I, that the para was reply.
I did not ask for paravis. I asked your stand with regard to the claim made by the
So-
petitioner. And this is again the copy paste of what was there, the earlier one.
My lord.
Yes.
So okay, may I pray that I may be allowed
Who
to
prevented you?
file an affidavit, my lord, so
You
that I
got
can
this
bring.
on 26/3. And today we are 1, 2, 3, 4, 5, 6 day. At least you
No,
produced it.
Today I received, my lord.
Yes, Mr.
My lord,
Solia, what is your case?
they were appointed, salaries were paid for some time, then it was discontinued.
Now, one thing, Mr. Chalia, have you appeared before the screening committee?
Yes, my lord.
You appeared.
Yes, my lord. Twice we appeared.
So, the appointment is doubtful, that means in your case. And if the appointment is doubtful, how can we question the conclusions of the screening committee? Screening committee did not find her eligible for teacher or tutor.
My lord.
Both, neither.
No, there is no report, sir. There is no such report.
Hmm?
There is no such report.
What to do? Unfortunately, it's 25 matter. Okay. We'll have to have a report then. Mr. B. Talukdar shall invariably file an affidavit on behalf of the respondent presented by him on or before 24/4/2026, and therein bring on record the recommendations made by the screening committee concerned with regard to the claim of the petitioner for withdrawal of area salaries as well as regular appointment. Withdrawal of regular salaries quickly. So, register to list this matter again. A week will do thereafter for you to
My
file
lord, my lord.
on 11/5/2026. In the meanwhile, the petitioners are at liberty to file a rejoinder in the event an affidavit is so filed. It is provided that the event the affidavit is not so filed, not brought on record, this court will proceed in the matter by applying the principle of non-traverse.
Can it be on 12, my lord? Because 11 I have some repair.
12, no problem. 12. Can take this back.
Obligement.
They are supposed to file affidavit.
Oh. In how many cases have you seen them filing affidavits? Why are you expecting against hope?
Yes.
Make your arguments. Mr. Khatoniar will argue on law, no problem. Yes.
Then, my lord, some other day, my lord, my.
Why? You started off with saying that they are not filing affidavit. That means you are ready, otherwise because of the affidavit is not. The higher secondary director has filed an affidavit.
My lord, that is not clear, my lord, as per the law.
Something is there.
Yes.
Something is better than.
But they have not, my lord, published, my lord, second list as per the.
He says that that is not required because how many vacancies were advertised?
Total vacancy, my lord.
Yes, Mr. Khatonia, how many vacancies were there?
1424.
1424.
Yes, my lord.
And in terms of the
Provincialization.
director's affidavit,
Lodge.
1238 have been appointed. 1265.
Yes. And
What about the other posts?
102 for government.
There are some reserve posts, my lord.
Hmm.
There are some reserve posts that are vacant, my lord.
You
And
did not get candidates.
no, my lord.
So the balance is reserved. What? 1265 minus that earlier advertised post.
This is
You have not said that in your affidavit.
that that has not been mentioned in the
You
affidavit.
were supposed to file a.
Regarding publication of there is a query, my lord, regarding publication of select list. Whether select list was
No.
uploaded in the
First you could not, then you were supposed to file 2 more. You were select means what? Further churn from that thing.
Yes, my lord.
And if somebody is eligible to bring them and appoint them.
Yes.
Not done. They are below the first select list on merits.
Yes.
So they say that other people having gone vacancies, so bring us. For that, you will have to create a select list.
That, my lord, regarding that, my lord, initially there was in the advertisement, it has been mentioned that there will be second or third select list. But subsequently, addendum, we have clarified that there will be only one select list, my lord.
Where is your addendum?
Yes, my lord, addendum was issued on 16/10/2014.
It's on record.
Yes, my lord. It's on record, my lord.
Page number 40.
Page number?
40.
Yes.
Yes, my lord. Preparation of merit list, my lord, page 42.
You all are graduate teachers, postgraduate.
Post-graduation.
No. This is the normal of preparing one select list. Where have you said that no further select list will be obvious? Because in the advertisement, the condition is there.
Yes. In advertisement, that is there, my lord.
Hmm.
But here, my lord, for verification of qualification and other particulars of the candidates, a draft merit list will be published with a ratio of 2 candidates against 1 vacancy. Thereafter, after verification, the final merit list will be prepared from the draft merit list as per outcome of the verification report and as per merit list draft ratio 1:1.
So, if you can't fill up all the posts, this same very exercise you have to again carry out for 2 times. That is your prescription, because you can't have a select list more than 1:1.
Yes,
It
ma'am.
has to be 1 FRBM. It has to be 1:1.
1:1.
Now you do it. Still vacancies exist. People don't come. Vacancies exist. You said that, okay, we will go to the pool. You have a pool.
Yes.
And then again prepare a select list 1:1. This time also we can't fill up. We'll go for a third round. Thereafter, it doesn't happen. Why those 2 exercises?
That has not been done, my lord.
It's what we wanted. Why are you not giving us that?
Because, my lord, in fact, we have clarifying that position, my lord, we have subsequently filed an affidavit, my lord.
Yeah.
Yes, my lord. Page 1.
Affidavit in opposition.
Additional affidavit in opposition.
When did you file?
It was filed on, my lord.
You got a copy?
Yes, my lord.
You got a copy?
So in my lord, item number, my lord, in.
I have filed in, my lord,
5366.
5366, my
Number
lord.
item.
5366.
You are there in 5366?
Yes.
Aha. This is exactly what you are saying. That is not the intent. That cannot be the intent. You can't have a select list beyond 1. 1:1 ratio. So you can't understand that to be a modification of your earlier.
But that is the understanding of the department, my
No,
lord, they have,
that is a wrong understanding. And
They
a
have-
director having this understanding, I'm sorry, we can't accept that.
because admittedly, my lord, after publication of the final select list, no select list was published, my lord.
No
Got
need,
it.
but see, you have yourself in the advertisement projected.
Page 36.
In case any post remains vacant after publication of the first merit list as per ratio so and so, then maximum 2 more list of merit list will be published. Now, where is that there was no vacant post available? That you are not, it's not your case.
No, in case, in fact, in affidavit, that is not our case, my lord, till now.
So why not? These people have come through a process of regularization, of process of selection. Then you have projected. Why will they not have a grievance?
But there is, as per my knowledge goes, my lord, they are below the cutoff mark, my lord.
Oh, first round cutoff mark, they will be below. That is why the 2 for more, the cutoff mark will come down. They may come in. They or otherwise, others are there who would come in.
Maybe, my lord, there is a fixed cutoff mark. That I'm not sure, my lord.
What
There-
about
there may be a-
what about F? Have you amended F?
No, my lord.
That exercise that you are doing is pre-F.
Yes.
And if it doesn't happen, again you go back to that exercise and then you come to F again. Doesn't happen, again you go back there, do it, come back to F. Finished. 3 times.
To that effect, my lord, I think I should have
We
a
are
clear,
adjourning the matter.
I should have a clear instruction, my lord.
That is exactly what this court required you. He quoted everything in details.
Yes. While pursuant thereto, my lord,
I
this-
can understand.
pursuant thereto,
My orders, the education department does not understand. Because maybe my English is not very clear. But this order is very clear. Very details it has.
Yes, my lord.
written. Then,
pursuant to that order, my lord,
So
this
now-
affidavit,
I think I'll
Was
have to
filed.
start interacting directly in a language known to them.
in fact, my lord, this affidavit was filed pursuant to that order, my lord. Order of,
But here you have not taken that stand with regard to, this is not a stand. This is not something which is born out from there. Convince me that this is what you meant in 2 select list. You have amended that. Convince me.
that was not amended.
Yeah.
That was not amended, but that understanding is that, my lord, since they have subsequently in an addendum, they have,
Addendum, what did they do? That we will call 2:1 and then verify, then
Then 1:1.
prepare 1:1.
I think I should have a talk with the department. That's better, my
Better.
lord.
On the prayer of Mr. N.J. Khatonia, learned counsel for the petition, registry to list this matter again on 8/4/2026. On the next date of listing, Mr. Khatonia shall receive concrete instructions as to why the projection made in the initial advertisement that in the event after the publication of the first select list, the posts are not filled up, there would be 2 more select lists published. So, the director, by way of filing an additional affidavit, has contended that in the corrigendum, the respondent authorities had undertaken to prepare the select list by considering 2 candidates against 1 post at the stage of verification and thereafter to prepare a select list in the ratio of 1:1. That is 1 candidate per post. This court does not accept such projection made inasmuch as the condition with regard to filing of 2, preparation of 2 merit list after the initial merit list was so published and vacancies being available has not been found to have been amended by the corrigendum. Accordingly, Mr. Khatonia shall receive his instructions and apprise this court on the said issue on the next date of listing, that is on 8/4/2026.
Can it be after Bihu, my lord?
Your director is not going to
Well,
Election duty?
No, my lord, I have some difficulty, that is why I'm.
Oh, you have difficult. Then fine. On 24/4,
Yes, my lord.
2026.
Obliged.
Yes, Mr. Nutt, what are you waiting for?
39.
Even, eh? Oh, yeah. Oh, that
University.
university matter.
3 dates have gone. No affidavit till today. Lordship's last order dated 9/3/26.
Mr. Kerala is very soft with them.
No, Lordship.
That is the reason.
But what's happening? Out of 13 months, now 9 months remains for retirement of the position seller. And now Lordship kindly see, my lord. At least, let him not to take major decision, my lord. That interim order may be passed. So that they'll file the affidavit. Very fast day when motion was moved. I didn't for an interim order purposely. I told the honorable court not paying for, so they let them file affidavit. 3 dates.
That time the order was also pending.
Yes. That's the reason. I purposely didn't make a mention.
Yes, Mr. Kerala.
Lordship, I have received instruction. I am going to file within a week. Lordship.
Such a prompt, and you, Mr. Nutt, just you.
I failed to read his mind.
I told you, no,
He
he's
is
soft,
soft.
but
He-
he's effective.
He threw the big shot.
No, he's soft, but he's effective.
Lordship,
And why is the UGC so eager to say something? Yes, please.
No, my lord, since I am a party here, my lord, I will.
Oh, only because of that you are here. Or you want to say something?
My lord, I have not received any instruction. Just now also I sent a mail that I need either the counter affidavit or the instructions by day after tomorrow.
Everything will come with one small interim order. Everything will come in. Within 1 week, everything will come.
Sir, Mr. M. Nath Lanat, Senior Counsel, assisted by Mr. Your G. J. Kapil, Learned for the petitioner. Also heard Mr. S.C. Cal, Learned.
5 and 6.
No, Mr. H. Chomo, Standing Counsel.
10.
Standing Counsel,
Use this.
and Mr. S.C. Cal, Standing Counsel, Assam University.
As well as private respondent number 6 also.
Yes.
On and also the counsel for the respondent number 6. There will not be a conflict of interest here
Lordship, probably not.
because he's projecting against that only, na?
Yes, Lord.
Ajib Mohan Pant.
Yes.
Okay, it's up to your at your peril.
UGC is the main respondent because
Okay, whoever is the respondent.
lots.
The case in the present writ petition, notices were issued. First, the present writ petition, the respondents, the petitioners have assailed, have prayed for a writ of quo warranto. Have assailed the continuance of the respondent number 6 as the Vice Chancellor of Assam University, Silchar. Also, notices in the matter were issued on 18/12/2025.
15/12.
15/12, no, 18/12. 18/12.
18. Oh, there's a mistake in the order. Subsequent order.
18/12.
Yes.
18/12/2025. The matter was thereafter listed on 3/2/2026 and on 9/3/2026 and on the both and on the set dates. Basing on the prayer made by the Learned Counsel for the respondents, the matter was adjourned to facilitate filing of the affidavits. The respondents have not brought on record any affidavit till date. While Mr. Cal has submitted that he has received his instructions and would file the affidavit on or before 8/4/2026, Mr. Chamua has fairly submitted that although he had taken up the matter with the UGC authorities, no response thereto has been received till date. Also, considering the above, this court fixes the matter on 24/2026 the respondents to file their affidavit invariably by 8/4/2026. In the event the affidavits are not brought on record by 8/4/2026, the respondents would be permitted to file the affidavits only after payment of costs, as would be now determined by this court on the next date of listing. Also, the present order be communicated to the respondents by the learned counsels for the respondents after downloading a copy of the same. 20, if they don't file,
It's all right. Mine.
either the Bar Association or our Employees Welfare Association will get some money.
Right.
You can have that pleasure that you have contributed to that. Yes, Mr.
No, my lord, it is on, that is, I'm not saying it.
It will be on. We are open, transparent.
Well, these people are not responding, that is the difficult.
Then you better resign. You resign.
That can be.
That's the only way, only advice I can give you. If they are not resigning, they're giving you, that means they are indirectly not giving value to this court through you.
Scant
don't want-
regard.
Scan regard. So we don't want that to happen. Resign. Continue with your practice. Resign.
Let's see, my lord. I'll communicate.
We know how to. You move out, we will deal with them directly. No problem. Next day you come and tell us, this is the
Yeah,
thing, you move out.
I'm not going to.
No. You move out means that
Yes, yes.
you allow us to directly deal with the respondents. We know how to deal with it. Whoever they be.
May I please, your lordship? Your lordships kindly see the last order, 12/3/2026, ma'am.
Yes. Elementary, standing counsel, secondary.
Secondary, ma'am.
Who is for secondary? This court, while order dated 12/3/2026, had recorded the submission of the learned standing counsel, secondary education department, that a joint sitting of the education department along with the finance department for consideration of the cases of the petitioner would be convened shortly. A meeting could be convened shortly, and the cases considered therein. On the prayer of the learned standing counsel, the matter was directed to be listed today. However, yes.
My lord, action taken report is yet to be received, my lord. That has not been provided.
What
to us.
about the meeting?
Meeting has been convened, my lord.
Today, Mr. N.J. Khatonia, learned counsel for the learned standing counsel, secondary education department, submits that the meeting has been held. However, the decisions as arrived at therein is yet to be calculated.
They have in the communication they have mentioned action taken report is yet to be received. Whether it has been convened or not, that has not been specifically mentioned.
Then
But
what? You said you will be convening it.
right now I have go to the.
No, I don't know, Mr. Khatonia. Why your officers are giving you vague things?
Yes, my lord, that is vague, my lord.
Why?
Because they have not mentioned whether it is convened or not.
That's what we wanted to know.
They have just
Simple.
mentioned it is
Action taken report. What is this big terms they are using? For whom? For this court? Simple things. Let us remain simple.
Yes, my lord.
Yes, give me.
Whether it is my lord, give after some time, my lord, I'll just
Done.
get the specific
Ito
instruction.
lah, right. Who is the lady, who is the teacher who has now been working as the academic thing? Academic in charge. You have made some reference about some teacher sending, what do you call that, gradation list, this, that. Who is the teacher? Who is the academic in charge now?
No, I have stated that one Munidipa Sikdar
Monidipa Sigdar
was holding the post of principal.
No. You have said further that there is a lady there, there is a teacher who is now wanting to have the post of academic in charge.
In my representation.
Somewhere. Who is that lady?
He's a male person, Lordship.
Male, okay, what is his name? One assistant teacher of the same school. Who is that? Is it Vijay Bhushan Das?
Yes, Lordship.
Vijay Bhushan Das. Yes. Why Vijay Bhushan Das was not given the charge of the post of master?
Because I am the senior most of the in the school, Lordship.
But the gradation list at page 17 shows Vijay Bhushan Das as the senior.
But there is a condition regarding eligibility that one should be less than 57 years.
He is more than 57.
Yes, these 1, 2, 3, serial number 1, 2, 3 are all above 57 years.
Okay.
The condition is there in the rules,
Okay.
Lordship.
Yes, Mr. Katonia.
Here, my lord, today I have sent a affidavit for vetting, my lord.
What is your stand in the affidavit?
But she was taking on leave. She was on leave, my lord. That is why, my lord. It was
Now she has
requested.
come back.
Yes, my lord. Incumbent to appoint would render his best possible service to the school in the greater interest of the student community. She was continuously taking leave. That is why, my lord, it was not considered.
What are the periods of leave they had taken? Which are the periods?
Period, my lord, here in the instruction period has not been mentioned, but it was
Mr.
prepared
N. J.
and
Katonia,
sent, my lord.
Learned Standing Council. So and so submits that and the affidavit has been prepared. And on vetting, the same would be filed before this court on or before 21/4/2026. Registry to list this matter again on 27/4/2026. No further adjournment shall be given for filing of the affidavit. Considering the submission of Mr. Katonia that the affidavit has already been sent for vetting.
Lordship, may I point out one small thing, Lordship? He is presently 56 years and 4 months old, Lordship. And once she becomes 57 years, she will be.
I've only fixed the matter on
Obliged.
20 or 20, 27. She will not become 57.
Obliged.
May I please the lordship, my lord, in item
And
number.
Mr. You were already given. It is a question of, and it was kept in abeyance.
Kept in abeyance.
If we set aside the kept in abeyance, the original order will come into being and you will be.
But that is only for in charge. I have a prayer also for regular promotion.
Regular, it will take the normal course whenever it happens.
No, but the rule says, Lordship, every year a process has to
Next
be
day we
conducted.
will consider.
Obliged.
And it is not the school only. Now it is district.
District, Lordship.
Whenever it comes up, it comes up.
Yes.
May I please the lordship, my lord, in respect of item number 2930, my lord. My lord, today itself we call the Commissioner Health, my lord, but he has been deputed for election observer in West Bengal. The election process will be completed on 4th of May. So he will be back after completing formality. I have informed my senior advocate, Mr. B.D. Das also.
We have kept it only on 5th or something.
5th, but he will come back probably on after 3-4 days of the election. Then we will have.
Election is 9th.
No, West Bengal.
West Bengal, 4th is the counting everywhere.
Yes, my lord. After
counting only, he'll come back.
Yes, my lord. After counting also some response will be.
When shall we fix it?
My lord, your lordship may fix on 15th or
15th, no issue.
15th or my lord, 19th Tuesday.
Have you taken the consent?
Yes, my lord. I have informed Mr. B.D. Das.
19. You have informed?
Yes, my lord. I have informed.
19. Good, you
yeah. Obliged, my lord.
Yes. You want to file a reply? No.
I want to share an order.
Want to file a reply?
Lordship, subsequently another writ petition has been filed by the present petitioners, and in that the status quo has been ordered, Lordship.
So what is there here?
Lordship, the only anxiety on my part, Lordship, after the stay order, this order has been passed by the IMD and Agriculture University. That's why I'm just handing over. Because if the grievance that has been raised in this particular writ petition is in respect of order dated.
So 31-3, your period was there. There is no
Yes.
extension thereafter.
The scheme has been extended on the basis of that submission and some documents that court has passed an order.
And what is your prayer in this writ petition?
In this writ petition, the setting aside of the order dated 17-1 and 22.
Is
20
number 19. I said.
We set aside these two orders. We are interfering with these two orders, but your prayer is to only continue till 31-3-2026.
Yes,
That is
but,
over.
but subsequently that
That writ petition, whatever it is there, you continue there, but what can we do here?
yes, Lordship, the
Withdraw this. That is the end of the matter.
Lordship, the only anxiety on my part, the original stay order was passed in this particular writ petition also. So and this has some connection with the
Lordship may make an observation that it would be subject to outcome of the other case.
or Lordship may merge the present interim order with the
That cannot be. With the other case, how it?
But Mr. Leaders, learned counsel.
only anxiety, Lordship. One order, Lordship.
I'm
that I have-
protecting you, don't worry.
Lordship. There is a gap in our services, Lordship.
That you take care. Heard Mr. Didas, learned counsel for the petitioner. Also heard Mr. RKD Chaudhary, learned
I'm for 1, 2.
Learned Devai SGI, appearing for the respond number 1 and 2. Anybody else?
For 4.
Mr. I. Bhattaku, learned standing counsel, Assam Agriculture University, appears for the respond number. The petitioner in the present proceeding assailed an order dated 17-1-24 and 22-2-2024, by which 17-1 is at page
17-1, Lordship. Yes. Page 28, Lordship.
28,
28. And 22-29.
by which the decisions, by which a decision was taken for discontinuation of services of the the persons engaged in the district agromet AGROMET units, and for winding up of the said units. Further, for continuation of services of persons working under Gramin Krishi Mausam Seva. This you are not Gramin, you are
Gramin Krishi Mausam Seva.
Mausam.
There are
What
two-
we do is, Mr. Why poor people, they have to come back again. We'll tie up this with that.
Yes, Lordship. That would be based. It's fixed on 28, Lordship.
Understand? He does not have a prayer. This has become infructuous. But see, there is an interim order here. Few 1,000 rupees they are getting. Finish off your case there.
There would be some difficulty, Lordship. He's making a prayer in this.
Beyond day,
He's making a prayer till 31st, all right.
we give it.
But then,
So how do we continue after 31st?
Lordship, there is
Lordship,
my site in the present, the
So
new.
your prayer is only till
Yes,
31st.
Lordship. Yes.
Lordship may make an observation that the findings out here or whatever observations will not
Let-
have any bearing on the other case.
The petitioners have filed the in present petition with the following prayer. Page
18 and
18, 19, ABC, huh? AB.
Lordship, if I may interfere, Lordship, this may put some impact because today, this morning, one of the petitioner approached the Agriculture Universities for certain document from the Agriculture University. They are saying that you are no longer our.
Actually.
Yes, it will have some impact.
Because after this prayer, you have got your relief here. We can't take it on more than what.
Can it be tagged with that matter? It is coming up on 28 lots.
Doesn't, you, whatever happens, happens. So, as the petitioners herein, in terms of the interim directions passed by this court in the present proceeding, have continued in their respective services till 31/3/2026, in terms of the reliefs prayed for by the present petitioner, in the present petitioners in the petition, it is seems that the relief as sought for has already been received by the petitioners in the matter. Accordingly, no live issue arising in the present writ petition, the present writ petition stands closed as having become infructuous. However, it is observed that, however, it being brought to the notice of this court that the petitioners herein have instituted another writ petition being WPC number
1705 of 26 to
1705/20
2026.
2026,
Praying for extension of the
praying for extension of the
continuation of the service.
praying for extension of the scheme and for continuation of the petitioners therein.
Scheme is continuing, Lordship. We are praying it as the scheme is continuing. Our service.
For praying for continuation of the petitioners beyond 31/3/2026, this court observes that the closure of the present writ petition would not be that upon closure of the present writ petition, the rights of the petitioners for continuation against the scheme in question shall be subject to the outcome of the above noted writ petition, that is WPC number so and so. Finished.
That's
With the above observations, close positioning.
I'm obvious.
Young boys come, we will have to protect their
Yes,
interests
yes.
also. That's it. Promising people next. So we should give them that boost.
Lordship, I'm not,
You are very young.
yes, Lordship.
You are the youngest in the bar. Yes. Who is the Tezpur University? Where is the compliance? Yes, madam, where is your compliance?
Lordship, Respondent 3 and 4 have not communicated anything to us
Uh-uh.
as of now, Your Lordship.
Get Mr. Kaushik. They said that they have already communicated.
No, Your Lordship, we have not received any instructions
No,
or.
this cannot be. Where is the, this is a contempt. Where is the department?
Mr. Kaushik, if there.
Mr. B. Kaushik, yes, call him.
This is the instruction. Yes.
But last week, Mr. Kaushik submitted that the director has already passed orders towards compliance of the direction passed by this court,
My lord.
and the same will be forwarded to the Assam Agriculture University within a period of 2 weeks from today.
My lord. But this
Wait.
is my lord. I have received it on 31/3, my lord. It will here. It's not-
On 6/3, how could he, how that statement was made?
My lord, the matter is under process, my lord. The IS.
But he said that
My
orders
lord.
have been passed and 2 weeks we are sending it.
My lord.
Who misled him? Your director. Where is Mr. Kaushik?
My lord, he is not present today, my lord.
Okay. Registry to list this matter again on 8/4/2026, reflecting the name of Mr. B. Kaushik, Learned Standing Counsel, Secondary Education Department.
God bless.
Wait, please, Your Lordship. Should I have instruction not to press this petition as it has become infructuous?
Yes, why not?
It's become infructuous, Your Lordship.
Otherwise, we have got the updated clarification on the point.
What is your clarification?
Clarification is that also we have appointed one inquiry officer. He had inquired discreetly inquired into this thing. The institution was closed in 2019. That's because there was no training. He got his application in 2018. The reason of closing of the institution is there was no training. Second thing, Your Lordship, that the advertisement demands that the certificate is from a government institution. It is not a government institution. The owner himself told us. So accordingly, this application is.
Yes.
He has already been appointed, Your Lordship.
Where? Him,
No, subsequently by a different
withdraw it.
Lordship.
Let him withdraw. Mr. M.H. Loskot, counsel for the petition. On instruction submitted by the petitioner desires not to press the present petition any further inasmuch as he has been subsequently appointed in a government service, and accordingly he prays that he be permitted to withdraw the present writ. Does not desire to press the petition further. The petitioner has subsequently been appointed a government service. Accordingly, Mr. Laskar submits that he be permitted to withdraw the present writ. Prayer is not objected to by Mr. C.K.S. Sharma Burwa. Also, accordingly, the writ petition stands dismissed on withdrawal.
Merciless.
Yes, Mr.
All correction is required, Lordship. Pin code is already just. Lojima code, pin code is also. It may be 3, but it also written 4, Lordship. Respondent number 6, Lordship.
You file an interlocutory application, will allow it. Can I otherwise permit you?
Post title.
Mr. Alamge submits that he would file an petition, an interlocutory application for bringing on record the correct address of the respondent number 6. So prayer allowed. The registry to list this matter along with the interlocutory application now undertaken to be filed by the petitioner.
Lordship, the writ appeal is yet to be listed.
What?
Writ appeal, we have filed a writ appeal with delay condemnation.
You take time.
Lordship,
You take adjournment, no instruction.
Lordship, take it up
You take time that you
in
don't have
reopening,
instructions.
Lordship.
No, you take time on the ground that you don't have instructions.
No,
No, sometimes the medicine has to go back also.
Now he has the liberty, my lord.
Yes, what happened? Appeal not disposed of.
no,
It is not listed, my lord.
listed. Lordship, there was some more defect. We corrected it last week, Lordship, Monday or Tuesday, Lordship. I think it will be listed within this before because Lordship may take it up in the May first week or second week, Lordship.
You don't have a stay. The violation is there.
Lordship,
What is the error here? They have gone up on appeal, Upendas.
no, here basically, Lordship, they were saying that though they have been regularized as master role, but they have been working in grade 3 post since their
That is
appointment. It was
Heard Mr. N.J. Katonia, learning counsel for the petition. So heard Mr. B. Chaudhary, learning counsel for the respondents. Mr. B. Chaudhary submits that the appeal as filed by the state respondents against the judgment and order dated 19/10/2020 in WPC number 0133/2012 is yet to be considered by the division bench of this court. He submits that steps are being taken for getting the matter listed expeditiously. Also, registry to list this matter again on 6/5/2020.
Obliged.
Obliged.
Yes.
Matter relating to pension miller. A matter was placed before the mediation center miller. My part is clear miller. I have appeared, but the other party not appeared miller. That's why miller remand back miller.
Both the parties failed to appear.
In this case, Miller, earlier Miller court directed to disburse the pension Miller proportionate manner Miller. But as per impugn order Miller, case 41.
Has the copy been served on service steps is complete on respondent number
6.
6?
6. I have gone through. I have gone through that. This is
Notices have not been issued in this case.
notice may go Miller.
You are the first wife or second wife?
Second.
You do one thing. You go and file. She is not giving you. She is receiving.
Yes, Miller.
Then you go and file a maintenance case in terms of the full bench judgment. What was the full bench judgment name? Junufa Bibi. Right? They're disposing it of. We can't go beyond the after the other than that of the full bench. File a maintenance case.
Against the first wife.
First wife will receive pension. You can't receive pension. 50-50 is not. If she is not giving, you go before file a pension in the terms of that Junufa Bibi full bench. Go before the court, claim your maintenance.
And then, my lord, I have to take instruction, my lord.
What
After
instruction?
Bihu matter may be fixed.
Huh?
After
Today-
Bihu matter may be fixed, my lord.
Today we are closing it.
No, my lord. After Bihu. After Bihu, my lord.
You want money expeditiously. We are giving it to you expeditiously. Second wife will approach the, you know the case of Junufa Bibi.
I have no knowledge.
A registry to list this matter. You go and read Junufa Bibi today.
Yes.
A registry to list this matter tomorrow.
Next week, my lord.
No, tomorrow.
Next week.
I'll forget tomorrow. Tomorrow.
Obliged.
Monday kori dia. Monday, huh?
Monday. Obliged.
You read Junufa Bibi full and come and
Yes,
explain.
my
it.
lord, yes. I will go.
May I please, your lordship. Lordship, in this matter, only as per the mediation report was unsuccessful.
Only this much. Yes. What is your case?
My lord, this matter pertain to the non-payment of the DCRG. No affidavit has been filed by the respondent.
Oh, you tell me your case. Why are you entitled?
My lord, in this matter.
How long have you been in practice?
My lord, actually, no record with me.
Oh, you have not taken a license. When did you join the profession? Here, when did you join? When did you become an advocate?
22, my lord.
22. Okay, argue.
No, my
Argue,
lord,
argue.
Actually, my lord, no record with me, my lord. My senior, he
A
is
second file to read. Read this. Come back.
my lord.
We'll take it up after 5 minutes to read.
My lord.
Registry to list this matter again on the learning council for the parties assembling. Registry to list this matter again on Tuesday for further hearing. You are there for the respondent. Oh, what is this you are doing? Huh? Sangeeta Roy, before that. Now you again cut 3 years and you say you don't have quality. You are the one. Whoever it is, we are now going to impose cost. You read and tell me. You read and tell me. Huh? What is this? Huh? You deduct 3 years. Those are antique. Sangeeta Roy has come. Then what more is report? Yes. Sanjita. I argued that case from the respondents at least for 3 years. Yes. Last week,
My lord, pleadings are complete. Let the matter be fixed for hearing.
On the prayer of Ms. Bidas, learned counsel for the petition, registry to list this matter immediately after the Bihu vacation for admission hearing. My lord.
Notice of contempt notice was issued. We have taken steps, but office note says that the service awaited. Report on 18 to 2000.
Mr. HK Sama, learned counsel for the petition. Seen the office note dated 18 to 2025, which reveals that
It should be 26, I think.
26, which reveals that the service upon the respondents number 1 to 5 is not complete.
Today we have filed affidavit.
2 to 5. 2 to 5 is not complete. Ms. S. Chutia has appeared on behalf of the respondent number 1. Setia has appeared on behalf of respondent number 1. It is seen that the notices upon the respondent number 2 to 5 were issued on 5/9/2025. Accordingly, petitioner to take first steps for service of notice upon the respondents number 2 to 5 by way of speed post. Steps within 2 working days from today. But registry to list this matter after 4 weeks from 4 weeks. Also.
56 also, my lord, awaiting service report.
Same order. You are comparing for one. I do Ali, date to hobo notice issue kora 28/2025. Speed post.
Three cases, along with 3 cases, an order was passed by the honorable coordinate bench. But the one case, main case was appeal filed, my lord. Appeal was not admitted.
You take steps. You take steps. Initial.
My only one, my lord, already appeared, my lord.
54, 55, we have passed orders. Separate. List
Please, the lordship, my lord, in this matter, my lord, there was an impediment application filed by the petitioner, my lord. An impediment application was filed by the petitioner that was allowed, my lord, by this honorable court. And again, that impediment of respondent number 4, my friend appeared for recalling of the order, my lord, or deleting him as a respondent. And that IA 2240 is, my lord, for which the matter is came for orders, my lord.
When was he impleted?
Impleted on, my lord, 18/12/24, my lord. On 3939 IA, my lord.
Yes, Mr. Sinha.
May it please your lordship.
You were not heard when before in pleading.
No, I was not heard.
What is your ground?
Your lordship, may I just pass on the,
Oh, forget it. Tell na.
yeah, the ground was that we are the agencies who finance or sponsors the various state agencies on various projects. Like we have sponsored we have financed the Assam Forest Department for a development
Yeah,
project.
why do you want if agency from France to be implemented as a party?
My lord, the project is, my lord, sponsored and all the my finance is provided by them. My salary
But they are not directly providing finance to you. They are providing finance to the state
to
government.
the state government, yes, my lord.
State government is giving it to you.
Giving, but my,
Oh, what will they do?
but my lord, whether the project is ongoing or whether the project is closed
That
or
is
not,
for the state. That is for the state to say, for us to say.
maybe it's not necessary, but a proper party.
No,
my lord,
necessary,
formal
proper,
party,
both
my
are
lord.
not there. Then in
Because-
every case wherein a scheme worker is there,
Yes, my lord.
we'll ask the people to include the ADB, World Bank.
Yes, your lordship.
These are just finances.
Yes, ma'am.
They
Finance.
finance that
Yes.
scheme. Scheme is of the state.
Yes, my lord. Project is depend on the finance of the.
Okay, we'll see it after vacations.
Your lordship, the only thing is that suppose if we are arrayed as a party respondent, he may have a claim against the state government. I'm not on that. This creates a blot on us that why we have been arrayed as a party. So therefore, before proceeding with the case, whatever his case is, that we may be deleted, your lordship. That's the
Which
first.
consider that. Third the Learned Council for the parties. So, registry to list this matter again after the ensuing Bihu vacations on a date to be fixed. We'll see on the next.
Deeply obliged, your lordship.
Yes, what is your case?
May please, Lordship. Lordship, in this matter, my lord, husband of the petitioner was initially appointed as a officer Khalasi in the year 1992, my lord, under the respondent number 3, my lord.
When did
And-
he die or retire?
And his service was regularized on, my lord, 22/7/2005, my lord.
Mm.
After the death of the husband
Hmm.
of the petitioner on 16/10/2023, my lord.
Hmm.
The pension has been paid, my lord, but the
Demonized
DCRT has not been released, my lord.
2013 or 19.
Under the respondent number 3, my lord.
So, okay, Monday, I'll pass the order.
Obliged, yes.
And next time you come before me without preparation, without knowing the facts.
May I please, your lordship?
Hmm.
Lordships, I may permitted 30 seconds. This is a matter, your lordships, where my case is,
You
That-
want me to meter it? No.
well, notices were issued in this matter. This is a second round of litigation, I must fairly admit. On the 1st of April 2025, a coordinate bench of this court directed me to file my representation along with all the requisite proofs to the IOCL. Now, post filing that, my lords, IOCL reiterates its finding, which it does in 2019. Now, my lords, my limited case is that I fall within their advertisement itself. It was a post which was for marketing
Who
professionals.
is this? What is the role of this Association of Indian
Yes,
Universities?
Millards, it is their own clause at 1.4, which says that candidates having postgraduate diploma in so and so must go to AIU to seek equivalence in their own interest if required. That is clause 1.4. Your lordships will have it at page
Have you gone
35.
to that institute?
Your lordships, what had happened, once I appeared for the exam, my results were withheld for want of clarification. IOCL themselves write to AIU saying that you please clarify to us whether this is equivalent or
Okay,
not.
show me the advertisement.
Lordships may kindly have page 35. Page 35, your lordships.
2-year full-time regular course leading to postgraduate diploma.
Diploma in master's degree in
person
business.
or equivalent with
Or-
specialization in marketing or an equivalent qualification from a recognized Indian University Institute. Where is your qualification?
Lordships may kindly have
annexure P2 is my qualification at page number 43, Your Lordship.
Global Business Operations Program.
Yes. Now, what,
Postgraduate diploma in global business operations.
yes. Now, I'll just clarify, Your Lordships, what happened after I appeared for the examination, I appeared for the interview, they withheld my result for want of clarification. Now, thereafter, they write to AIU saying that you please clarify, which is at page
Where is
50.
that clarification from AIU?
AIU does not clarify. AIU says on at page 53 that you please go to SRCC and seek a clarification. SRCC is the college from where I did my PGDM. Now, SRCC clarifies this at page 56, where it says postgraduate diploma in GBO is not equivalent to MBA, but its course curriculum has specialized subjects in marketing.
That cannot be.
Manoj, if I may.
So,
if I,
you are Mr. Garg.
Yes, Manoj.
Once they say that they want a postgraduate diploma
Yes.
in marketing,
Yes.
or a master's in what do you call that? Master of Business Administration.
Yes, MBA.
So anything therein would be equivalent.
Correct.
So your course cannot be, your own university says that it cannot be held to be equivalent to either these two.
Correct.
Or only it has some specialization in marketing.
Manoj, their clause itself.
And the law is very settled now. The interpretation here, we'll have to give it to the employer, not to the employee.
Manoj, I fairly bow down to what's following from your lordship.
So if that is there, fine.
Manoj, may kindly have clause 1.1.1 for a moment at page 35. My entire edifice of my case rests on this.
1.1, 2-year full-time diploma course leading to postgraduate.
Postgraduate diploma in masters.
We understand postgraduate diploma, PGDM, master's degree in business administration to have some connotation.
Correct.
That is their understanding.
Correct.
And they said, okay, you have raised an issue with regard to the equivalence.
Yes.
If they had the faith, or if they had decided that this is equivalent, there was no point. They would have not withheld you. They would have put you in.
That's correct.
There was a doubt. They sent it to the respondent number 3.
Yes.
From respondent number 3 said that no, you go to the
college.
And the college has said, no, this is not that. Finished. That's the end of the matter.
Manoj, may kindly then.
What more is it?
I will satisfy your lordship.
No, satisfy me now.
Your lordships, there are rulings which say that insisting solely on the degree without considering
I'm sorry, there are decisions also. I'll quote it, don't worry.
No, Manoj, I bow down. I bow down to what's falling from your lordships. But your lordships may kindly appreciate that in this matter, when the 1.1.1 itself says or equivalent with specialization in marketing, Manoj, SRCC, when they write back to the IOCL, they say this at page number 56, that postgraduate diploma is not equivalent to MBA, but its course curriculum has specialized subjects in marketing. And your lordships, I am only...
Well, they don't want it. They want somebody which is fully marketing. How can we go and...
No, Manoj,
Their view, we'll have to give value.
Manoj, no, I appreciate your lordships. What's falling from my lordships? Your lordships...
Where is the earlier order of this court?
Manoj,
Your lordship, at page 86.
Page 86 is the final order. This post was kept vacant until the 1st of April 2025 via an interim order passed on 13th of March 2019. That's when we filed the first writ petition. Now, your lordships...
Now, have you filled up that post?
Your lordship, my senior, due to his personal difficulties, he went, but he told me, your lordship, that so far on the earlier
You
occasion,
have taken lunch today.
I had.
Then open up.
No, sir, earlier on the last petition judgment, it was said that since more than 5 years had passed for the issuance of this petitioner, is he interested to join as a professional marketing? On page 89, your lordship, point number 12. Your lordship, since he is mentioned about the clause 1.1.1, it is also said that the court also noticed that question to whether
the post-graduation diploma in global business operation is equivalent to pay to any other post-graduation diploma in marketing has not been specifically addressed either by the University of Delhi or by the Sri Ram College. Hence, the petition was disposed earlier also.
Exactly. The conclusion, para 10.
Yes, sure.
Okay, where is your representation with materials
Milords,
to
may
show that
kindly,
it is at least equivalent to postgraduate in diploma?
Milords, may have page 91 onwards.
Yes, where is the material?
Milords, we have annexed, Milords, may have page 94,
Hmm.
serial number C, Milords.
Hmm.
It says the matter relating to the details of PGD in GBO being a full-time course.
No, I'm not on that. Where is the declaration of that equivalence? That is what the court required you.
I will show that, Milord.
Come to page 89. To
Milord,
produce relevant document evidence before the authorities in form of a representation.
that's correct.
Establishing that the so-and-so is equivalent to postgraduate diploma.
That's correct.
So show me.
Milords, may have
material.
page 63 for a minute.
63. Okay.
This is an RTI appellate authority reply. Because, my lords, the only recourse which I had was to move an RTI because the Shriram College of Commerce had already clarified to me as well that I have specialized.
You don't have it, you don't have it. We can't help it because last time that direction was, you go, give your clarification. You don't have it, that's the end of the matter, Mr.
Kindly
Counsel.
see para 11.
We'll not go for a roving inquiry here.
No, that's correct. Your Lordship, the High Court cannot decide the matter of equivalence.
Let us close it.
That I
It's
bound-
already past my
My lord,
sitting time. It's past my sitting time. You wanted 30 seconds. I gave you 10 minutes. Now that I think I should close it.
My lords, may kindly appreciate that number one, the service for R3, which the last order.
Forget R3. You did not want that also. I pointed out. You did not want. I'm not going back. R3 is not a, we'll delete him. You have made your submissions, we'll pass out.
My lords, may kindly appreciate that at para 11 of the order passed by the coordinate bench, it specifically.
Coordinate bench, I am concerned with the direction. Direction is at para 13.
Direction is at para 13. Your lordships are absolutely correct. But my lord, may kindly also have para 11 for a moment.
Let us give it a closure. It's been lingering for too long.
My lords, the only reason I'm saying the post remains vacant.
Let it remain vacant. Let them go and file it, fill it up in the manner they require. We are not concerned.
My lords, the counter at least may.
Why? You wanted 30 seconds to argue the matter. You have argued for 10-15 minutes. We are dismissing it. Today it will not be possible. I'll fix it tomorrow or day after and we'll pass the orders. Heard Mr. C. Learned Counsel for the petitioner. Also heard Mr.
N. Goswami.
N. Goswami, Learned
For
Counsel for the respondent.
One
Also, the office note, office Laujima court order, notice the Laujima court order dated 25/3/2026, which reveals that the service upon respondent number 3 is not complete. Also, however, in the context of the issue arising in the present petition, this court is of the considered view that service of notice upon the respondent number 3 is not called for. The learned counsel for the petitioner had argued the matter on merits. Also, the petitioner, the learned counsel for the petitioner has been heard. Also heard Mr. N. Goswami. Mr. Goswami has also made his submissions in the matter. Also, in view of the above, hearing concluded, raised it to list this matter on Wednesday for delivery of orders at 2 p.m.
Obligation.
Yes, Mr. Goswami.
Let's say as per last on Laujima Court's order yesterday, Laujima Court has observed that I should take step on respondent number 2. It was not complete. But by this time, Lordship, the selection was challenged regarding selection of the post of headmaster in BTC area. already there is an order from this honorable court to, because junior has been appointed and it should be considered. Now BTC has passed an order, set aside the whole selection.
Oh.
But in the authority, in the affidavit, they have stated another thing. I got less mark that was not appointed. Now they have cancelled whole selection.
Lordship, affidavit has been filed on 6/2/2026.
And the order
This
is,
order was 12 March 2026.
They are going to conduct fresh selection.
who will place this? You or Mr.
Lordship, the petitioner side.
This one?
Yes.
You don't have instructions on.
I have taken instruction over message, Lordship. The document is correct. They have, the person is in
Mr.
meeting.
S.K. Goswami, in the present petition, but Mr. S.K. Goswami and Mr. B. Chaudhary, Ms. B. Chaudhary,
And sorry.
N. Chaudhary, learned standing counsel, BTC. The petitioner in the present petition has raised a grievance with regard to his superstition by his juniors in the matter of promotion to the post of headmaster of provincialized college situated, provincialized school situated in the district of Buxa district under the Bodoland Territorial Council. Also, Mr. Goswami has submitted that the BTC authorities in the affidavit filed in the matter had projected that the petitioner was placed lower than his erstwhile juniors on merits, and accordingly his case was not considered for such promotion. However, Mr. Goswami submits that the Secretary, Bodoland Territorial Council, via a communication dated 12/3/2026, had intimated the Director of Education BTC about the decision of the council to cancel the recommendation made by the Departmental Promotion Committee, BTC on 4/3/2024 for promotion to the post of headmaster/headmistress under Baska district on account of clear violation of the provisions of Rule 14 of the Assam Higher Secondary Education Provincialized Schools Service Rules 2018. Accordingly, the Director of Education BTC was directed to initiate a fresh process of selection, strictly adhering to the provisions of Rule 14 of the Assam Secondary Education Provincialized Schools Service Rules 2018. Also, accordingly, he submits that in view of the above, the selection process having been interfered with, the grievance raised by the petitioner in the present stands redressed. Also, accordingly, he submits that the present petition may be closed in terms of the said communication dated 12/3/2026. Ms. N. Chaudhary, learned standing counsel BTC, does not dispute the contentions made by Mr. S.K. Goswami, and also with regard to the communication issued by the communication dated 12/3/2026 issued by the Secretary, Bodoland Territorial Council. In view of the above, the selection process involved in the present writ petition having already been interfered with by the cancelled by the BTC authorities, no further live issue arises for consideration in the present writ petition, and accordingly, the present writ petition stands closed on having become infructuous.
Petitioner case will be considered in the next election. Otherwise, it will be difficult for me.
Also,
Fresh, they are going to take up a phrase. So
in the event a fresh process of selection is so considered, is initiated, the case of the petitioner shall be extended with due consideration, along with others, strictly in accordance with the provisions of Section 14 of the said rules of 2018.
next.
A copy of the communication dated 12/3/2026 Furnished by Mr. S.K. Goswami, learned counsel for the petitioner is kept on record and marked as X for the purpose of identification.
Publish.
Ase aru? Oh, itu dia, kita dia. Due to paucity of time for today, could not be taken up. Registry to list this matter again. On date, but yeah, all khali dukhe. 28-4. Itu logai dia kedina. 32. Pasto. Oh, itu aru eta ase no? No. Tini. Oh, no. 42 dia. তাই না তিনি এক দুই তিনি তো কি কৰিলো সাইটো দিয়া সাইটো নহয় yes who is appearing for
Yes, I mean,
yes
herein the issue is simple issue.
it's a very simple you tell me that's why I wanted you
The
you are
service of
running
the
away you're not
petitioner
coming
the service of the petitioner was terminated by invoking the provision of sub-rule 1 of rule 5.
hey, very good what is
But
why
my guess is that your lordship, the appointment order says that the
you have not been confirmed
lordship kindly see
you
that.
have not been confirmed
Yes, I admittedly
oh,
that.
forget that Mr. Khan come to the meat of the matter what is your date of birth
My case is only that, your lordship.
tell me
The
what
date
is
of
your
birth,
date of
your
birth
lordship, they have found that the
you want to work in a discipline force with a fourth certificate. Huh? With a fourth certificate, you
Yeah.
want to work in a
No.
discipline force.
definitely not, your lordship.
Then come to the
I am-
affidavit.
I am saying, your lordship.
No, come to the
The
affidavit.
provision, which one?
Come to the affidavit.
Yes. But with regard to this affidavit, your lordship, although I made attempt to file my objection, your lordship.
Forget it.
But-
This affidavit
but-
says 10-10-1988.
Yes.
From where did you produce this? You have not disputed production of this.
That's one only I am saying, your lordship.
You
But
denied. You have denied.
I could not file
No,
my
no,
reply, your
forget
lordship.
Mr. Khan, poor people, these are, you tell me you deny that you have not filed this. Just deny that. That you did not produce it before the authorities, just deny. That'll do.
My case, your lordship, kindly see.
Your case
I-
I'll come,
this is-
whether you produce this
I
or not,
got this, your lordship,
whether you produce this or not. Affidavit,
regarding that aspect, your lordship, I
You
need
don't
to
know.
take instruction because
you don't know.
presently I
You
I
don't
have
know.
no any.
Okay. Then come to page,
That's on only, your lordship, I am submitting, your lordship. Regarding this affidavit, your lordship,
no,
presently
you come
I
to
do not
page,
have.
you come to page. First annex, second annexure. Page 13.
Page 13.
This is genuine. This is genuine. Or you have doubt about this also. You have doubt about this.
If your lordship,
You have annexed it.
no. This is annexed by my friend.
No, this is your writ petition, my dear.
No.
This is your
Oh.
writ petition.
Page 13.
Page 13.
Yes.
You admit this?
Yes.
That is the end of the matter.
Yes.
Likha.
But I am only saying. your
Okay,
lordship,
you
the
want your birth
provision order-
certificate. Birth certificate.
No, birth certificate, not your lordship. The appointment order. says
That we are not going when it is
The
for.
service of the petitioner
I'm
will be
putting a
governed.
Supreme Court judgment, don't worry. While dismissing your case, you want your this birth certificate to be considered. Do you know when you got the birth certificate registered? 2013. Huh?
Yes.
Where is the DC's permission to register this? Not, you have not said anything. Under the Births and Registers Act, if it is beyond 1 year, there is a procedure. Lekha. Oh, I to be totally dismiss. I think I should have imposed cost here, but poor man, I'm not doing it. Too much. And
Yes.
what is this certificate HSLC private examination? Yes, Mr. Barmiya, have you heard this? HSLC private examination is the private seva also.
If somebody don't goes to school and appear from home.
That is private candidate.
Candidate.
It cannot be a private examination.
Yeah.
Where is your client? You are in touch with him?
No,
No, then dismissed. The Mughal.
public.
Mr. Khan is there. We are not going to take any serious thing here, but yesterday when I was seeing this, I did not like the thing. Yes, Mr. Bhuya, what happened?
My lord, with item 18, my lord, I find it.
I'm extremely sorry, my lord. My lord, the file from government to send back to the director, my lord. That's why some miscommunication is there, my lord. So I pray little accommodation, my lord.
Okay. Mr. B. Talukdar submits that on account of a miscommunication occasioning in the matter between the respondents, the proper instruction could not be furnished to him. He submits that the instructions would be furnished in writing received from the Director of Secondary Education Assam.
Elementary, my lord.
Huh?
Elementary.
Elementary Education Assam on
Immediately after vacation, my lord.
on 9
my
to
lord.
Bandha, 10 Bandha, on 8/4/2026. In the events, he said instructions are not received, this court, in addition to posing cost, would also require the personal appearance of the director before this court on a date to be fixed.
Obliged, my lord.
Here, the meeting has not been convened, my lord.
Mr. N.J. Khatonia, that is what we want. That much you
Yes.
tell us. N.J. Khatonia Learned Council, Standing Council submits that on account of the election process, ensuing elections, the meeting that was proposed to be convened could not be convened. He submits that the matter be taken up in the first week of May, and by that time, he would pursue the matter with the respondents to have the meeting convened and to take a decision with regard to the petitioner's case.
The date being fixed.
Accordingly, registry to list this matter again on 6/5/2026.
Obliged.
Baki duta by. Huh? Itu kuntu dilo pavitra boratu Petra disutu. Sorry. এই দুটা 2-7 কৰি দিয়া আৰু এডেনটো অলপমান পজিটিভ দুটা আব্দুল ৰচিদটো পজিটিভ টাইম এইটোত মই অৰ্ডাৰ দি দিছো 6 তাৰিখে মই অৰ্ডাৰ দিছো 5 কৰিব দিছো দুইটো পজিটিভ টাইম on 6/7/74 আৰু এইটো 28/4. Yes, anything more?